guests. We are ready to, the board, is my mic on? Now it is. Thank you, members and guests, for the slight delay. We are now ready to open the meeting. Ms. Richmond.
Chairwoman Harkey,
Thank you.
I'm calling the roll.
Yes, call the roll. I'm sorry. I miss a month and look what happens.
Chairwoman Harkey.
I'm here.
Mr. Runner. Ms. Ma.
Here.
Mr. Horton.
Here.
Ms. Towers.
Here.
Thank you. Appears we have a quorum, which we knew we did before we started, but let's begin. We have Pledge of Allegiance, and I want to announce that this morning we're going to commence with the pledge led by Security Officer Annette Harris. Ms. Harris has been working at the BOE and the CDTFA for 11 years. Prior to being a security officer, she was working in retail. Ms. Harris is married to Heron Harris, Sr., who is also a security officer at FTB. She has a family of yours, mine, and ours, 6 children, 13 grandchildren. She is a new grandmother to a darling 2-year-old baby boy, whom her daughter adopted to become the brother of 3 sisters. Annette is a devout member to the Allen Chapel African Methodist Episcopal Church and is also on the Board of Trustees for the church. Ms. Harris and her husband will be on vacation in April, taking a long-anticipated cruise. Now, does that tell you a lot about this woman? Come up, Mrs. Harrison, please. Lead us in the pledge.
I pledge allegiance to
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much, and thank you for your service. Okay, Ms. Richmond, next item.
Good morning, members. Our first item for this morning is item C, public hearings. We'll be putting this item over until later in the day.
Mr. Michaels, who is here to present, is still stuck in a little bit of traffic, but will be here shortly. Thank you. Next item, please.
So our next item is item E, tax program non-appearance matters adjudicatory. Item E3, property tax matters. We have 2 Section 40 matters. These are constitutional functions, therefore the Deputy Controller may not participate in these items under Government Code 7.9.
Thank you.
Madam Chair?
Yes.
Just for clarification, these matters, I understand that they're constitutional functions. These 2 cases was decided by the board with Controller Yee here in December. So my question really is to Chief Counsel, considering that Controller Yee was here in December and cast her vote, is it still a constitutional matter with respect to Section 40, which is not a constitutional item?
At this point, you can participate in the discussion. However, for the vote, I would recommend that we have the board members, exclusive of yourself, vote on that matter.
Okay, thank you.
Thank you.
Thank you.
Really answer the question.
Okay, members, is there any discussion here? Okay, do I have a motion? Ms. Ma moves,
Second.
seconded by Member Horton. Any objection? No? Such will be the order. Thank you. Okay, next item, Ms. Richmond.
Our next item is item F, other tax program non-appearance matters. Item F1, we have property tax matters. These matters may be taken in one vote, and these are also constitutional functions, and therefore the Deputy Controller may not participate in these items under Government Code 7.9.
Thank you. Do we have any speakers on these items? Is the staff coming forward?
No speakers.
No speakers, no staff. Okay. Let me see. Can we take these all in one?
Yes.
Madam.
Okay.
Madam Chair, I'd like to have staff come forward and make somewhat of a presentation, at least for the public.
Yeah, I think
know
everybody needs to understand what it is we're voting on. Thank you very much, Member Horton. Please introduce yourself for the
Yes,
record.
I'm Dick Reisinger, Chief of the State Assessed Properties Division. And what's before you are property tax audits that we've completed, and so a role change relative to corrections in role, and then also a land assessment for unreported land that was escaped, and we assessed it.
Okay, it looks to be like there is support from the taxpayers for these changes, or acknowledgement of them. Is that true?
That's correct. For the three audits, the two of them, they actually consented and agreed to the findings. The third one, we discussed with them and asked them for additional information. They didn't express any problems, and they didn't provide us with any additional information.
Thank you. Right, members, do you have any comments? Okay, there are 1, 2, 3, 4, 5 of them. Do you want to take them on one vote? Do I hear a motion to approve?
So moved, Madam Chair.
A motion to approve staff recommendation by Member Horton. Is there a second?
Second.
Second by Member Ma. No objection. Such will be the order. Thank you very much.
Thank you.
Our next item is the administrative session. Item J is the consent agenda. J1, we have approval of board meeting minutes for December 11 through 14, 2017, and also January 25, 2018.
Members, is there any discussion? Is there a motion to approve?
Move to approve.
Move to
Second.
approve by Ms. Stowers, second by Member Ma. Without objection, such will be the order. Thank you.
Our next item is item K, other administrative matters. Item K1 is the executive director's report. Item K11, we have the organizational update.
Thank you. Mr. Kenny.
Morning, Chairwoman Harkey and members. Dean Kinney, Executive Director. Today I'll provide you with a brief update on a couple items. In reference to CEA positions, I'm pleased to announce the appointment of Ms. Lisa Thompson as the Board of Equalization's Taxpayer Rights Advocate. Ms. Thompson started her role as the TRA in January 31st. I told you we were hopeful of doing it shortly, and we have. We're pleased to have Ms. Thompson aboard, and I'm looking forward to working with her. In reference to the Chief Legislative Research and Statistics CEA position, the position was posted on January 12, 2018, and the final filing date was February 1st. We hope to be completed with the recruitment process by the end of March. In reference to other BOE staffing matters, as I mentioned to you at our prior meeting, effective February 1st, 2018, the California Department of Tax and Fee Administration staff working in the Legal Entity Ownership Program, Tax Area Services Section, and the Welfare Exemption Program returned to the board via an interagency agreement. Also, along with that staff, we received 4 attorneys who would formerly work with the board. They're now back with us, and we're very grateful to have them back. They're assisting us on getting some projects that I'll touch on later moving, so we're very appreciative of having the staff back. On budgets, CDTFA continues to work on updating accounting and budget processes and systems to handle information for both BOE and CDTFA. We'll continue to send you regular updates as information becomes available, and as happened in the past, feel free to come back with us questions, and we'll try to answer them as quickly as possible. Just a little bit on some projects that we're working on and engaging interested parties on, and we hope to bring to the board later in 2018. And these are the ones that getting staff from legal staff has helped immensely getting these going. Airlines representative period. We're currently working on it now, analyzing issues related to the possible change to a 365-day airline representative period. As you may recall, this item was before the board, and you directed us to work with parties. There was an interested parties meeting held yesterday to discuss the issues, and we have a second meeting scheduled for March 29th on that matter, and we'll keep you apprised of progress in that area. And we'll be bringing this matter back to the board. I think we're asked to bring it back either June or July, so we're shooting for that date. Assessment appeals process. We're working on addressing concerns about the assessment appeals process that was brought up at the August 29th, 2017 board meeting during the Property Taxpayer Bill of Rights hearing. We had an initial meeting with parties, a small group of players in December. We're opening it up to a larger interested parties process. We've received comments. We're distilling them down in a matrix. We'll post that, and then we'll meet with parties, and we're hopeful that will happen in April, and then we'll be moving on that. Again, this is a project that getting the legal staff back has been very helpful because many of the matters are very, very legal in nature.
And isn't there an expected date to bring it back to the board?
I don't know if we have that yet. I don't know, Mr. Young is in the audience. I don't know if he wants to come up and address it or just nod and say we don't have that, or we do have it. We don't have it, so we'll have a better idea after the April meeting. So.
Okay.
Community land trust properties, this was a bill that passed a couple years ago that set up kind of a new valuation scheme for affordable housing for that's sold to low and moderate income families. It has a 99-year lease on the land, but the improvements transfer. It's a new model, if you will. During the legislative process, we met with the land trust folks. We've talked to them several times since then. We've talked to assessors. We traveled to some assessors' offices to talk to their people that have these. We're in the process of drafting guidance on that, and we'll issue that to interested parties, and then meet with them, and then work it through the process and bring it to the board later in the year. Deed rescissions is another project that we're working on. We're going to try to consolidate into one letter to assessors, kind of the guidance we have in numerous legal annotated opinions. We want to distill it down into one location for individuals. And again, we'll work this through the interested parties and bring it back to the board. And ultimately, we see this one going into, maybe later this year, moving into an update of the Assessor's Handbook 401, which is the change of ownership manual. So, and then we'll open that up to the interested parties process as well.
Can you just go back and talk a little bit about what deed rescission? I don't understand that.
Deed rescission, so property owners in some instances has the ability to rescind a recorded deed, and then it kind of rolls it back and untriggers the change of ownership. So it's kind of complicated, legal issue. We have a lot of legal opinions, and we think for guidance to all parties, it'd be better to consolidate it into one document. So.
Okay.
On that note, and just kind of in general, I understand that you guys do have a lot of projects and that you're working on, and you do come to us once a month and you kind of give us a high-level update. I really would appreciate if we had more of something in writing that I could really review and understand what's going on with the different programs. The Franchise Tax Board has something similar that they provide to us, to their board members on a monthly basis. So we just have a good understanding of the operations so we don't have any surprises. I think Ms. Ma, all three of you guys are familiar with the Franchise Tax Board hot list. I really would appreciate if BOE would consider doing something similar for this body.
Right.
We could do that. I mean, last month I did one memo kind of going that way, but I could reach out to the Franchise Tax Board and see what their model is and work towards that.
Okay, thank you.
Okay.
Thank you. If you need any assistance, I think, we have somebody that might be able to do that too. So,
Yeah,
you need some.
I'll reach out to Sylvie Stanislaus. We worked together here at the board many, many years ago, so
Yeah.
I'll reach
I'm
out.
sure she'd be willing to help you on how they put together that list.
Okay, thank you.
Thank you.
So that just covers my update. We continue to work with CDTFA as we work for the transition process. We thank them for their cooperation and patience in working with us. We'll continue to send emails to the board members and communicate as we progress through the process and give you monthly updates. And at this time, I'm happy to answer any questions the board may have.
Madam Chair.
Yes.
Thank you, Madam
Member
Chair. Well, welcome, Mr. Kinney. On the Taxpayers Advocate, does the agency anticipate coming forth with an outreach and education plan strategy at some point?
We've talked about it. I mean, as you know, under the statute, and so we're tasked with providing guidance and training to county assessors. That's our audience by the statutes. We understand the importance of having the people educated to the taxes, and so they know how to proceed with filings and everything. So we're looking into that. Ms. Thompson and I have discussed. We're kind of maybe we develop some publications and so forth. But as far as developing an outreach program, we'll be out providing training. At this time, we just don't have the the resources or the budget to do that. So we were hoping to kind of analyze the recurring questions that are coming in and see if we, we can turn, kind of like the deed rescission, the individual opinions into larger, broader guidance. So, but in this case, towards taxpayers. In the past, we developed Publication 30 to help taxpayers navigate the appeals process, primarily for residential individuals, not people represented by tax reps. We developed a video that's online for that, so, Ms. Thompson and I have talked about that and see what we can do down in that, given our resource levels.
So at some point, you're going to share that with the board, your strategy that...
Yes, we can do that.
Many of the assessors have expressed a desire to have additional training, and that the board is their primary source of training, knowledge, and so forth. And one of the efforts is to assure that there is uniform treatment throughout the state of California and that they're all on the same page. As a result of visiting many of the assessors, I see that there is a serious need, and they concur, at least the ones that I've been able to speak to, for this additional training, if for no other reason than just to bring about a level of uniformity in the level of skill set, the capacity, and the knowledge of the changes in legislation that's relative to them, and that the board's overall constitutional duties. So I look forward to that. On the interested parties meeting with the airline representatives, what were the issues discussed?
May I call Mr. Young up? I was not at the meeting, but Mr. Young led the meeting.
Good morning, board members.
Good morning.
Yesterday, my name is David Young, Chief of the County Assessed Property Tax Division.
Could you pull your mic up a little bit, Mr. Young?
Of course.
There you go, thank you.
Of course. Yesterday, we had interested parties meeting. The chief subject of discussion was the alternative of using the 365-day representative period for certificated aircraft. LA County and the aircraft subcommittee made a presentation on their analysis and the work they've done. It was a cursory review. Thank you very much.
I know.
It was a cursory review. We have in attendance were also the vendors that provided some of that data, and we have scheduled actually another meeting for the 29th to further vet the actual nuts and bolts of the actual analysis that LA has done on that. So that was the main thrust of the meeting.
Did LA indicate that they are representing the association, or whether they're on their own behalf?
Well, LA is, my belief is that they were the subcommittee. They are the CAA subcommittee of the CA, the body itself. So I know they did most of the analysis of the work there.
And you indicated there were more than one vendor present?
Yes, sir, there were two.
Two?
Yes.
And who were they?
One was Flight Global, and the other one was OAG.
And what was their assessment as to their ability to provide the data for a 365-day analysis?
Both were of the opinion that they had the information to do such a representative period.
And is the BOE anticipating a review of that information in the capacity?
Yes, they have sent us, we have one data set. They sent us a preliminary data set which represents 1 week of that data for 2 major airports in California, and we are actually in the process of reviewing that information right now.
Any input from the industry itself?
Yes, industry was represented there. Industry's main input was that it would be burdensome and at the very minimum burdensome, if not impossible, for them to come up. If they had to report themselves, it would be really tough for them to do so.
And is it anticipated that they too will participate in the analysis of this data?
At least one vendor has expressed that the sample set which they gave, they are open to letting that be vetted full in the interested parties process. So at least one has so far.
The other vendor is not
Not
willing
yet.
to?
Their vendor has not committed to it, so.
Okay. Part of the challenge last year was with, well, at least there were a number of different issues, but one of the concerns was the whole notion of sole sourcing to a particular vendor. Let me encourage the agency to reach out and see if they can identify other vendors that can provide this data
Yes.
that's necessary in order to accomplish this objective. Let me also encourage the agency to work with all of the parties that will be impacted by the decisions that we make, because what happened last year is that parties indicated that they had not had an opportunity to review the data and had not been able to verify that the data was correct and accurate and so forth, and was available to accomplish the goal which we set forth. So to the extent possible, the interested parties meeting, at some point, we should be on par and make sure that all of the parties have an opportunity to participate in every level
Yes.
of the analysis and throughout the entire process. So we're not faced with having to deal with this a month or 2 months prior to the decision.
Yes, that is the goal we're working towards, sir.
Yes.
For the analysis that the subcommittee provided, was that analysis based on actual data or scheduled data? And if it's actual data, if we're looking to trying to do actual 365 days, do we need to have a law or a rule change? And if so, where do we stand on that issue?
The data that the one data set actually contained both actual and scheduled. So we are able to take a look at both. So if we are to move towards actual data, we will have to work with legal and figure out what exactly, if any, amendments to the Rule 202 will be required.
Is that are you working with legal right now? Because I've always thought when we talked about 365, we were
Yes.
talking about actual data.
Yes.
So are you guys making that step? 'Cause it seems that we need to have various paths to be evaluated.
Right. We have, legal is aware that we're working on this project. They have not been officially engaged yet, but we will.
Well,
Well,
part of the challenge is the
Yes.
legislative process itself. And so inherent in that process would be a further delay without the concurrent legislation moving through the legislative process. If in fact the 365 is what's the most accurate number and it's concluded to look at it on an actual basis as opposed to what the current legislation provided, we would be handicapped. We couldn't say, let's do that, or that's the most effective and efficient way to go at this, because we wouldn't have the legislative authority.
Board members, Henry Nanjo, Chief Counsel, just wanted to correct Mr. Young's statement a little bit. Legal has been involved. I have an attorney involved in monitoring the interested parties meeting, so we would be ready to make whatever changes necessary. I also I attended part of the interested parties meeting yesterday and talked to Mr. Young about it. There are several concepts that are being discussed by the interested parties group. So before we can draft legislation or do something, we need to kind of settle on what that is. One of the presentations that was made by LA, because I did stay for LA's presentation, was that by getting data that's both scheduled and actual information, at least their analysis was that they were hopeful that a rule change would not be necessary, because we still are using the scheduled information. We're just verifying it with actual data, if I understood what their concept was. So the parties involved are looking at several options. Apparently, there was a discussion of a model that I think the airlines brought up, the Texas model. Was that?
Yes, that is a model, the assessment scheme which Texas uses to allocate the value of the certificate aircraft fleet. It's basically very similar to ours, except instead of weighing the flight time and the landing and takeoff, it's just flight time. That's one of the proposals brought up by.
But
by
that's
airlines.
still 365, and that's still actual, so it seems to me that, our direction was to look at the ability to do a 365
Yes.
day, and with that direction, all paths should be looked into.
Yes.
Including having the potential of a rule change.
Right.
And I am somewhat concerned that nothing's been done on the ledge front as far as a rule change. To wait till after March, we might find ourselves backed up against the wall. So I would urge you guys to look into a rule change, at least drafting the language as soon as possible.
So with that in mind, that's why legal is involved from the very beginning. We're kind of monitoring it. The challenge is we need to know what we're drafting legislation toward, because 365, as I understand it, can take different forms from the discussion that was occurring, and it's not clear that, and correct me if I'm wrong, Mr. Young, that all the counties are necessarily county assessors are necessarily supportive of the 365 model. So I think we need to have a little bit more certainty before we draft legislation. But because of that, I do have an attorney who is involved at every one of the meetings.
Okay.
May I just interject here, just quickly? I feel like, I know this is not the proper mode of transportation, but that somebody's being railroaded here. It sounds to me like this train is rolling down the track towards 365 without us having any information and without everybody participating. And I'm not sure why there's such pressure. We've heard about this. We've had conversations about it up here at the board. I felt like the testimony that we got up here last time was strained, and I don't feel like the industry's getting included, and I don't feel like all of the county assessors are being included. I feel like this is like something that's rolling, and it's going to be back on our laps, and we will not have accurate or information. And I know you're doing what you can under pressure, but I do think that we need a little bit more discussion up here, and I would like to see a little bit more of the interested parties process coming before the board, and I think that's one of our discussion items, because this is a huge issue. This has been rolling around for years.
Yes.
And just set it on our plate with, this is what LA thinks, or this is what this one thinks. Every time we get into that, it ends up something happens in the legislature or something happens here, and we're back where we were. And so I don't want to have you spinning your wheels, and I want to be sure that the board members are fully informed going forward with who's participating, what the comments are, and I just really feel like we need a little more input here, because it's going to be dumped on our laps. And I don't feel prepared to make the analysis. So I know, we had this conversation, but it seems like it's being promoted by one or two. And I thought that LA was getting a coalition together, but I might be wrong. Excuse me, sir, did you have a comment?
Good morning, Chair Harkey, honorable board members. I'm Chuck Lenhart, President of the California Assessors Association, and I too was in Sacramento yesterday at an interested parties meeting, and I believe that there was a fairly broad representation at that meeting. Major airlines called in, they were there in person, a coalition of assessors were there in the room. When we talk about the Assessors Association and this issue, it's kind of interesting because I think there's only about 13 assessors that are actually affected by this, because that's where the commercial airports are. And in Plumas County, we don't have one of those airports, but it's a fascinating topic, and I've learned a lot about it. I think my take on the meeting yesterday was that a lot of good dialogue occurred. I think the one vendor agreed to provide a month's worth of data to the airlines so that they could take a look at it. It was an interesting discussion from the perspective that sometimes it seemed like the airlines told us they had information for us, and sometimes they told us they didn't have information for us, and I had a very difficult time really trying to analyze that piece of this puzzle. But the vendors seem quite confident that they can provide it. One of the questions I asked them is that they obtain most of their information from the airlines, and my question to them was, well, for the information you don't get, how are you going to provide that to us if we need to have all the data? And I think that's a question that still needs to be answered. But
See, this is what I mean. I don't feel like I have any information. Everybody else is out there giving information. We're getting some from the industry. We're getting some from the assessors. We're getting some assessors that are more forceful than others. I happen to have a letter in my book from one of the assessors that has been, I think, kind of abusive in the issue. I'd like to hear from other big counties. I'd like to hear the assessor from L.A., Orange County, and others come forward, and San Diego. We've got a lot of assessors that are affected by this, and I'd kind of like to get them, be sure that they're all part of the interested parties and that there's not just one county or another county weighing in more heavily. And I'd also, you're questioning already the data that's being provided by the so-called one vendor. How do you verify it? Where do you get it from? So I think there's a lot, and I just don't, I appreciate everyone's effort on this, because this has been a long going. I mean, I was in the legislature when this was being talked about, and I think it was being talked about even before I got there. What I don't want to see is something arrive at this board for a vote and then find out that it wasn't fully aired or that we're not really fully informed. And I think it's, you're on a learning curve trying to figure out where all the pieces fit, and I'd like us to be as well informed. And so, I think this is a real important issue for California. It's a real important issue for the assessors, those that will be affected.
I, as a trained appraiser and not an airline county, look at this process, and I think I've come to a similar conclusion that some of you board members have, that 365 it probably is the best way to do this if it can be done.
If it can be done.
If it can be done. And I think we're in the process. I think staff is, I thought they conducted a good meeting yesterday. There were a lot of issues that were put on the table. I think there's a lot of hard work that has to take place to be able to analyze this, to determine whether it can be done, and if it can be done in a way that's cost efficient.
Right. I just know, we're a little bit short of staff on the staff side, and I don't want to see them spinning wheels if the board members aren't like up to speed on what's going on. And I know Mr. Kenny and Mr. Young have their work cut out for them on all these issues. And so, as much for their sake as for our informational purposes, I hate to have them spinning around on an issue that's going to require legislation that we won't be able to get, or that's going to have data that we won't be able to verify. So, I just feel like I'm in the dark here. And so I appreciate you in your efforts. I truly do. We had a great conversation the other day, and I would love to have just a little more information brought to this board, maybe more involvement in the IP process so that we know what's going on. This is a very complex issue. It's not like, the law is this and so we're going to do this. It's a very complex issue. So thank you very, very much.
It is a complex issue, and to kind of reassure you, I think I've had a conversation with the Orange County assessor on this topic, and I think that at least in concept, he's not opposed to it, and he has had different visions in the past. San Mateo was in the room yesterday. Sacramento was in the room yesterday. The assessor you referred to with the letter was in the room yesterday. Los Angeles was in the room.
He's always in the room, isn't he?
That's not the purpose of my visit today.
I don't think, does he have an airport?
Yes, he does.
Oh, well,
Yes.
good.
So-
At least I'm glad to hear that.
And I think Delta was represented, Southwest was represented, there were a number of other representatives there. So I think you had a good cross-section of
Okay.
people
Well,
there.
we need
There was-
to know.
And
We
that's why
don't
I'm here
know.
talking to you
I mean,
today.
I appreciate your talking to me, but I still don't have a sense of what's going on. So thank you
Okay.
very, very much. Member Horton?
Thank you, Madam Chair. Welcome, Assessor. Congratulations on your election as President of the Assessors Board. The things that came into discussion when the board took the matter up was process, and that the process itself did not lend itself to the involvement of the decision makers as well as all of the parties who are involved. And as much as I appreciate the airlines being involved and the assessors being involved, the county itself, school districts, all of those folks are interested parties in any tax that's levied, property tax that's levied. And so why we're excluding the general public from this discussion, I don't think we should. I think they should be incorporated in the discussion to some degree. But I think the first step might be to just come into an agreement as to what the process is, because what parties may very well do is just rely on what process that we put out there, and they will participate, but they won't necessarily engage until a point in time that they have a difference of opinion. The Orange County assessor, for example, has an opinion, at least shared with me, that the board should be doing the assessment and not the assessors, similar to what we do with the railroad assessment, that should happen, and has sought legislation along those lines as well. The other issue that we addressed was an agreement as to, the parties were not in agreement as to whether or not the data could include, or the definition of the terms. And so they had different interpretations of what the terms were, and so the party that was providing the data would call X X, and they saw X as Y. And so you can never come into an agreement when you have these two different perceptions as to what this data actually says. And so I just think it's important that maybe what we should do is have a discussion just about the process and have all the parties come before us and come to some agreement. Not whether or not it should be an interested parties process, because I think it should be an interested parties process, because that allows the experts to get together and kind of flush out the facts, and I think that's important. But I also feel it's important that the policymakers are involved, not at the last minute, but as the process sort of evolves, so that we are aware of the complexities that challenges this decision. On the legislation, we can't wait. If, in fact, legislation is needed, what I'd like to have is just a legal assessment as to what would cause legislation to be needed, what would cause a rulemaking to be needed. We've been dealing with this for, God knows, 20, 30 years, so at least my experience with it. And so I think there are a number of situations where rulemaking will be necessary if it goes in that direction. I know that there are a situation where legislative changes will be necessary. And so, and pretty much know what type of rulemaking we will need to do, what type of legislation we will need in order to accomplish the various objectives. So at least a legal analysis that says, if we go in this direction, we're going to need a rulemaking process. This direction, we're going to need legislation in order to accomplish that objective. And then I think we need to be sensitive to the legislative process, which says that they have deadlines. If you don't introduce a bill, then we're faced with having to do a gut and amend, find legislation to put this in, and so forth. So maybe a conversation with the chair of the committee that would oversee this to at least see if this is something that could fit into an omnibus bill or some legislation, or if they're willing to put forth a legislative outline that will eventually evolve into legislation for the Board of Equalization. The deadline to introduce legislation is upon us. So I don't think we can wait to start that process.
From my perspective, I think contemplating whether you need legislation or not is something that you can invest some time in. But I also believe that your staff has put us on a fast track here to report back, because we have to determine whether or not the data source is accurate and get everybody to agree to that. And we need to think through the process of how this would be implemented so we know what legislation needs to be implemented.
Assessor Linhart, when you say we, you're speaking of the assessors?
I think we're talking about the assessors. I think we're talking about industry. I think we're talking about the Board of Equalization, all the players in the room that are looking at this issue and trying to determine whether it's practical.
See, what I'd like to hear I'd like to hear that come from the industry. Being experienced with this process and how it works, if you don't hear that from the industry, what I heard from the industry last time we took this matter up is that they had some serious concerns. This was a new issue to them. They had not had an opportunity to vet these issues. And so I'm not saying it's not working, but no one's telling me that that is the case. And so...
And I think it's important, too, to understand there is a bit of intimidation going the other way. I mean, it's their business. It's their, it's what they do. And so I think there's a little bit, they're a little bit remiss to actually say exactly where they're going with this stuff. And so I've always thought this should be a statewide assessment anyway. So I'll just throw that out there. I don't understand why every county's doing something different or taking one and running with it, but that's probably a bigger topic than we're here to get into. But I really do want to be fully informed before making a decision on this, and I want to be sure that everybody has a real chance to vet, because I know what's like when lobbyists or representatives of certain groups are in. They're sometimes a little bit closed mouth, and then they'll come back to us like in a later time and say something that, you just wish they would have said on the dais, but they're afraid to do that because, there's always the feeling that, they're afraid they're going to get cut out. So, and they don't want to find any kind of hostility from their assessors. So I think you need to understand the power that's there, and that's why I think we need to have more open discussion. Yeah, you're rolling your eyes, but it's true. County assessors
I didn't realize I was rolling my eyes because
county assessors are
I agree with you.
Pretty. It's pretty important. It's a pretty powerful position. So I think all industry kind of is a little bit cautious, eggshell kind of cautious when they're tiptoeing around these issues, and that's why I think a little more open discussion up here would be good. And I do appreciate what you're doing, Mr. Leonard. I do appreciate what you're doing. You haven't got an easy task, but and I appreciate our department, and I know that they're short, and I know they're under the gun, and everybody's trying to please everybody. But I really think that a lot of that needs to come back to the board, because we're the ones that are ultimately going to take the vote, and we're ultimately going to take the hits if something goes awry. So. And I want to support my staff every step of the way. Believe me, I do. I want to be sure they're covered and that everything's done so that they can feel comfortable with their presentation and that they don't get slammed after the fact.
Madam Chair?
Yes.
I agree. There's a lot of moving parts with this particular issue. And the industry may not, when they come before us, they may not lay it all out there. I did attend the meeting yesterday, and they were very open at the meeting and expressing their concerns, especially when it comes to the compliance burden. There was a lot of discussion about looking at all these data sets. And even, I believe, some assessors expressed a concern as far as the administration burden. My issue is that, to staff, you provide us with a high-level report on what took place, but we're not getting, I mean, unless a member of staff was at that meeting, because members cannot attend, so unless a member of staff was at that meeting, they didn't have the benefit of all that discussion. So I would really encourage staff to report back out to the members on what was said. You don't have to attribute it to any one particular person, but you need to be really open and frank on what the various parties are saying, so that the members can make an informed decision when we get to it, so we can see how, I'm going to say it, what we call in the controller's office, see the sausage making, you know. They need to see the detail. They have staff, very capable staff that can get into the detail and advise their member, but staff, you guys really should be presenting this information to us, and that so that we can see, the members can see both sides of the story. So I really encourage you guys to provide us with ongoing, complete reporting on this issue, so that when it comes back for a vote in July, we're not just focused on one little memo. And it's, you know, if it's anything like last year's memo, that was what, 30 pages?
Yes.
That's a lot of reading. And I really think the members would be best served to be updated on a regular basis.
Yeah, it's going to be a thorny issue, and as you well know, and we want to be sure we can support, you know, the staff, and that the staff feels comfortably supported. And, you know, I mean, the industry brings revenue to this state, and we need to collect the tax revenues, and so whatever, you know, I don't want them to find us less favorable and put less flights here. I mean, that could be self-defeating. And so, you know, I know we think we're so big that nobody's going to ditch us for another place, but I'm not really that sure anymore. I think that, you know, cutting down the number of flights, time in the air, I mean, there's a lot of ways that, you know, we could be served, but served less frequently. So I just want to be sure we understand that the proper amount of assessment is what we want. We don't want necessarily to be seen as gouging or that less friendly than some other surrounding states that might benefit off of our off of what we do here. We want to be sure that we're benefiting the people in the state of California to the maximum extent we can, and that we keep industry flowing, and that we keep the planes coming here frequently. It's really inconvenient. I mean, I think you all lived through the Ontario debacle. I did. You book a flight down there and it would cancel. And it's going to be up to the people who buy the tickets to pay for any increases or get the benefit of a decrease if it comes through. Ultimately, if this ends up being an overall tax increase, the ticket holders are going to pay the price. So, I'm trying to figure out where this is really going, and I think that we all want to generate the correct amount of revenue for the state, but I think it's going to be very important that we be very judicious and not just assume there's more out there and we need to get it. I would really like to see us understand who really pays for the tax, any kind of increase. So, on that, any more comments? No. Okay. Thank you very much. I appreciate it, and I think your direction is probably clear as mud by now. But, we just want to be sure we're up to speed. And Chief Counsel.
Yes.
Did we determine if our staff may sit in uninterested parties? I thought that was the point. We could do that because it's part of almost a legislative process. It's not.
The staff could attend, the board members cannot.
The members.
Yeah.
I thought that we could because, well, I'm not attending them, but Member Horton seems to have.
No, I don't. Historically, that has not been the case. And there is a decision, I can't remember exactly where the Chief Counsel previously said that the employees, staff of the members can also be part of the establishment of a quorum. by virtue that they're representing us, by virtue
Yes.
that they're communicating to us, and therefore, so their participation in the interested parties process on matters that will eventually come before the board would be
Limited.
in violation. So,
My understanding of that memo, Member Horton, is that board member staff can attend, however, it should not be representative of a quorum. So it's two members of two sets of staff members, or two members being represented is fine. It becomes problematic when there's more than that attending the interested parties. So
Right,
there's a
right. So-
limitation on the, I thank you for correcting me. There is a limitation on the number of staff members that can attend.
okay.
Okay, so wait a minute then, this just another conversation.
I didn't.
On behalf of Controller Yee, I do attend the IP meetings. Yesterday's meeting, Member Runner's staff was there, so we were okay on your two limit.
Correct.
But that's news to me. I've never informed anyone that I'm attending a meeting so that we can check that we don't have more than two.
Well, I mean,
And one more thing, and then so I also thought that your memo said that staff may attend, but they cannot express the opinion of their member. And I know at yesterday's meeting, I asked a question regarding actual versus scheduled data, not expressing an opinion of Controller Yee, but what was presented to us at that meeting, and I did look at you and ask you, you can let me know if I'm overstepping my boundaries. I'm a little confused now. I'm really confused on why staff can't attend an IP meeting.
I don't
so-
know
All
either.
staff
because
members should be able
they're
to attend.
interested
Sure.
parties.
Well,
So I could provide a little bit more information. The problem is, the concern that was raised by your prior chief counsel, and I also looked into it myself, is the potential that that becomes a serial meeting. And it becomes a serial meeting when a majority of the board members' staff are attending, and to the extent that those staff members either talk to themselves, talk to their members, you've created a potential serial meeting situation. So to prevent that, the recommendation by your prior chief counsel, and as I understand it, is also the recommendation of the Attorney General's office, is that you have for participation at an interested parties meeting, that you do not have a quorum of the board members' staff represented, which means you can have, for this board, two offices represented. Now, my understanding is that, and there is a motivation for this, that Mr. Young also asked for an RSVP, for lack of a better term, of board members, and that's so that we can monitor if there's more than two board members being represented at the interested parties meeting.
That's a difficult item to monitor, considering that they can always call in and not identify themselves on the telephone.
Yes, that's true. That is true.
This is kind of like the mushroom approach. You know, I'm sorry, but this whole process seems like, you know, we're being mushroomed and asked to vote, and we can't talk, and we can't listen, and we can't hear the conversations, which is why I think the interested parties meetings need to come before the board. We need to be here in a public forum, so there's no Bagley Keene, and we hear what's going on. And I don't mind doing that at all. I think it's really important that we know what it is, what the path is, and that everybody gets a chance to speak to the members that are going to make the decision. We're not appointed, we're elected, and I think it's, you know, I mean, I don't want to gum up the works, but I also don't want to, at the last minute, like Mr. Young experienced, where we reject his decision. I would like to have support for the staff recommendation, and I don't think I can have that if I'm treated as a mushroom. So
there are two things, Chair Harkey and board members, that the board can do within Bagley Keene and all the other laws that you're bound by. One of the things is, as been suggested, you can request that staff provide more detailed information, kind of give you, I use the terms loosely, blow by blow about what happened at the interested parties meeting. And at the same time, it's within your right to have meetings held here where the topic can be discussed through the board's agenda. So between a combination of those things, and I think, Chair Harkey, you mentioned yourself, one of the things you want to do is allow time for the parties to get together and kind of hash out the details. That's something that you can do through the interested parties meeting without the board's participation. So I think you could achieve your goals through a combination of the three, if you will. So.
I would agree, Madam Harkey. The interested parties meeting, when it's the experts drilling down on the issues, has enormous value. The inherent challenge with the interested parties meetings is the law that prohibits the decision makers from engaging collectively in that process, or in the information gathering, information assessment, analysis, and so forth. And so therein, the recommendation to at least have concurrence on what that process is in order to collaborate, in order to come to an ultimate agreement. Oftentimes, that never happens because the parties disagree on the process, and they disagree on the terminology and so forth. And the other challenges that exist with the interested parties is the interested parties are the people that we deem to be the interested parties, and the people that we send the information to and ask for them to come. When, from my perspective, the interested parties is the general public. At some point, has to be, not at the point that you're doing your analysis, not at the point that you're gathering the facts and so forth. The interested parties is the public. Interested parties is the decision makers who can't attend by law, can't attend, can't participate, can't deliberate, can't discuss, and so forth. And those are some serious challenges that have just been created. I mean, the notion of just ex parte communication doesn't exist for the most part, unless we're in this public environment. Technically or theoretically, there are challenges that have yet to be resolved. And so now the board members are faced with, as Member Harkey termed it, information being gathered, and then boom, here it is presented to you. And the inherent challenge with that is you have one party come to that meeting and say, I disagree, I guarantee it gets put over. Or I have a problem with the process, or I have, so you're creating an environment where the decision of staff can be easily challenged by an outside party. And for the assessors, as I've encouraged them, is that this process is a three-pronged process where you have the general public that has to make a decision, you have staff that's going to provide the expert advice that has to make a decision, and then you have the decision makers who are obligated to make a decision. You want to come to the table with all those parties nodding their head and saying, listen, we agree. If nothing else, we agree on that the process was equitable, that the data is, in this case, that the data is available and it can be provided. One of the challenges with the selecting of a vendor is that these vendors actually work for the airlines. And so the last time around, the vendor disappeared. I mean, just disappeared. And so that can throw a monkey wrench in the decision-making process. And just want to encourage you to try to figure out a way to address that. Dean?
Thank you, Mr.
Kenny,
Horton.
my apologies.
I guess my recommendation to Mr. Young and Mr. Lenhart would be, I think the board directed us to look into this matter and bring it back, I think, July. We've had an interested parties meeting. We're going to have another one in March. April might be too soon, and depending on what happens on some other things here, I know the assessors have a conference, but perhaps by the May meeting, April if doable, but the May we bring back before the board kind of where we are and where we've reached consensus, where there's disagreements. I think that's what the board's looking for, to hear that kind of information.
Are we supposed to vote on something in July?
No, this is, I mean,
In July, are we supposed to vote?
we were directed to bring it back in July, but I think there might be some benefits to, we will have a second meeting, we will have a better idea where we stand, to bring it back to the board in May and talk about where we stand, where we've reached agreement, where the rubs are, so the board would hear that at a
Yeah,
public
would we have
meeting.
everybody in here in this room so that we could actually have participation? We need to be sure we're notifying everybody, including the public, like we do, but probably.
It would be noticed.
No.
We could notice it.
Yeah.
I'm not saying an interested party, I mean, it's more, this is where we are, just.
Yeah, I think-
It's very similar to how when we went the representative period, and you were
Right.
able to delve into the details and find out where the problems were.
Okay. I just want to be sure that everybody's here, and I'm not hearing it, at the time for voting. And I think you understand that. It's really a difficult, and it's a very complex issue, and we've been dealing with this for, he says, over 20 years, which I'm sure we have. So, anyway, thank you so very much.
I mean,
And
point of clarification, Madam Chair, question of Chief Counsel. Do we have legally, can we vote on this in July? I thought the statute provided specific timelines as it relates.
I believe, Dean Keeney, I'll handle. I think the discussion was the board wanted the parties to engage, discuss, and bring it back. So instead of bringing it back at the end of the year,
Give
and
us-
still have things bubbling around, that the board would at least hear in July, and we can continue to refine it. But I'm suggesting instead of July, we try to move that first appearance before the board to May,
Okay.
to bring focus to the matter. So
Thank you. We don't want to stress you out. Just want to be sure we've got the
Oh, no,
information, and I always feel like we don't in issues like this till it's right at the very end, and we're trying to. And I don't know about other members, but some of my legal staff is not available. It's really a matter of myself digging into all these issues and then asking a bunch of questions. I have my people do the best they can, but it's it's a lot to get at the end. So thank you.
thank you.
Thank you for your time.
Yeah, a lot longer than I thought it would be, but I just want to be sure I'm not getting stuck. I don't want to be here going, ah. Okay, next.
Our next item is K12, the annual meeting of the board and county assessors and proposed
Before we
meeting
go there,
date.
just to
Sure.
to close it, I'm sorry, but I will, Chief Counsel, I really would like to see that prior memo that you're referencing. I know you sent us one memo, but can you kind of resend the prior memo regarding staff attending IP meetings, and then your memo where you advised us on how we can carry this out?
I will look for it. I've seen the memo. I didn't have a copy of it, but I will try to get a copy of it and provide it to you.
You've seen it, but you don't have a copy?
No, it was a CDTFA memo, so they weren't, at that time when I was looking at it, they let me look at it but not get a copy of it.
I'm
so.
pretty sure I have a copy of it. I'll see
Okay.
if I can
Yeah, if
find
you can
it.
send it to me, Mr. Horton, I can
Sure.
verify that it was the same one that I was shown.
This is the one that it said, the other option provided was to notice the interested parties meeting, so
Correct.
everybody could attend.
That sounds like the same one I've reviewed.
But inherently, the process doesn't allow for everybody to attend, and it's not even anticipated everybody to attend by virtue that it's held in a room that everybody can attend. You know what I mean? And
It was
so,
not in that room.
yeah, so that's part of the challenge. But it's not only the airline issue. Let me just share, there are just a number of issues that are coming forward from the assessors where they're expressing concerns, public expressing concerns, and the desire to, to have their elected representatives speak to their concerns.
Absolutely, I understand. Thank you very much.
Okay, next item, thank you.
Our next item is K12, the annual meeting of the board and county assessors and proposed meeting date, location.
Chairwoman Harkey, members, Dean Kinney, Executive Director, I'm requesting to revise the previous adopted board meeting calendar to include a date and location for the board's annual meeting with county assessors, as this meeting is not yet scheduled. You may, we had it scheduled for January, and then there was a scheduling conflict. We canceled it, so we're looking for a meeting date for sometime later in this year. The California Assessors Association is holding its Bay Area Association Conference from April 16th to 19th in Folsom to facilitate increased participation by assessors and minimize traveling costs to all parties. Chairwoman Harkey has requested that the annual board assessor meeting coincide with this conference. Therefore, an option for the board could meet with the assessors at this conference on April 18th. And then there's alternative conference dates list, though.
Okay, members, I think this is a good time. It's not too far from Sacramento. Those of us that can get to Sacramento can probably get there. I do question the 8:30 start time because of the flights. I will have to come in and spend the night, and I'm not sure that that's, what time?
We've checked, and Mr. Lenhart's here and can address things. We checked with the assessors, and if the board elected to meet with the assessors there, it would be a 10 a.m. meeting up there.
Oh, that's wonderful,
then
because
allow
then we
the
can
board to
fly
come
in
back.
the morning and then drive a half hour to
Right.
get there, and I don't have to spend the night in a hotel. That's good.
Chair
That works
Harkey?
for me, yes.
So we, set the schedule last year. I think we all, cleared our schedule. This is last minute. I probably won't be there because I've already scheduled a couple things for that day. So
I thought this was kind of floating around. I didn't think this was last minute, because I know we've been talking about this, and I thought that staff had checked with members. Ms. Richmond, can you verify?
I did check with members' availability, and I was informed that Ms. Ma would not be able to attend.
Okay.
Madam Chair, I agree with Ms. Ma that, we did go through setting our calendar for the year for our scheduled meetings. I recognize that we do have to have our annual meeting with the assessors, but our office, we have a concern with options A, B, and C in the locations, and really would like to see if we could have this annual meeting in December and have it here at our office. I know that we have a scheduled board meeting for December the 11th, and I believe the assessors have their wrap-up meeting on December 13th. It seems, I don't want to have
it's-
someone to come, I know you guys have to travel in, but
It's up for discussion. I'm happy to just fly into
I'm open to
Sacramento.
December 13th and having the annual meeting here. I think it'd be an excellent opportunity. We will have 2, 3, 4 new board members, and that would be a great introduction for them to meet the assessors as well.
Does that present a problem for the assessors? Are they wishing to meet with us sooner, Mr. Kenny?
Mr. Lenhart's here can address
Mr.
that.
Lenhart, I'm sorry, I want to be sure we're not pushing them off.
Yeah, that's a good question. Last year.
I don't think we have one.
I may have to request my own desk here.
Yes.
When we recognized that there was a conflict with the January meeting, I contacted Dean and we discussed a number of alternatives. The December meeting was one of the alternatives that we discussed, and I think I have already reserved a room for our December meetings, but I'm happy to adjust that if necessary to accommodate your schedule.
I'm fine with whatever we choose. I just want to be sure we're not throwing this meeting off so far that we're negating our obligation to meet. I want to be sure that the assessors aren't feeling like we're putting them off, or that this board is living up to its responsibilities towards the assessors.
I think the assessors recognize that these board members are very busy people, and this is a very busy year. And I think that
So December works for
we
everybody.
can work with you to create a valuable meeting, whatever time it takes, whatever meets your schedule.
I think December 13th, looking at our calendar, December 13th in the morning would work. There's an FTB meeting December 13th at 1:30, and somebody would be the chair. So that member will be coming to the FTB meeting as well. But if we do it in the morning time, it's workable. But I do have a question.
Okay.
When did we have the meeting last year? Did we meet last year? So are we talking about the annual meeting for 2017? Or are we talking-
2018, we had the
2017, I believe, wasn't it Napa that we met?
Was that the Napa
No,
meeting?
I think it was January.
It was
We
here.
minimized
It was
traveling
here.
for when we had it at the
It was here. We had
UCA's
breakout.
business
We had it here?
Yeah.
Okay.
in January.
And that's when we were trying to minimize costs by having it
Exactly.
here.
And then we attempted that again for 2018, and then there was a scheduling conflict with the governor, State of the State address. So we're in search of a 2018 date.
Well, I'm fine with whatever date this board wants to settle on. I don't have a problem with that at all.
And I'm okay with either December 11th or 13th. It's far enough out. And I think to save costs for all of our AV folks, because it's supposed to be publicized, or I think it makes sense to have it here in Sacramento. So whatever date, 11th or 18th, or 13th works for me at this moment, so.
Okay, let's settle on one.
How about the morning of December 13th? Isn't that, the assessors usually have theirs, they start the afternoon of the 13th and then in the morning of the 14th.
Correct.
Their year end, so.
Okay, December 13th it is here. Is there a motion to do that?
So move.
Second.
Moved and seconded, and any objection? No. Such
I
will
have
be
a
the order.
question, Ms.
Thank you.
Harkey. So does that mean that we are moving the board members' meeting from the 11th to the 13th? are we keeping
Yes,
that meeting
we
date
would be.
also?
We would be, because it'll all be on one day, is
Whoa,
that
whoa, whoa,
correct?
whoa, whoa.
Or no, you said
No,
FTB's on the
FTB meets in
13th.
afternoon, and the December meeting for the board will most likely include
assessors.
property tax assessees.
Okay, so then we have to do the 11th and the 13th?
That's what I'm checking.
Oh, thank you. Boy, are you quick.
I'm trying to see how we could do it with minimizing travel costs here.
Well, you
If
know,
we-
I mean,
if we
if we
do
have
it-
to fly up, it's a matter of if there's
If we
an
fly up,
overnight.
if
and
we
it's
had the
registered.
board meeting on the 12th?
I'm
you
fine
have
with,
one
I'm fine with
oversight session?
whatever we decide to do. That's far enough out, we can schedule around it. So I'm good. I just want to be sure that once we settle on this, it's done.
So what's going to happen in December again?
So have the board meeting right now is scheduled for the 11th. And
No,
I
I
think,
get it, but how about the board, the BOE board agenda for December? What do you anticipate?
the property tax.
Remember, it would be the property tax state assessee appeals, to the extent there are any that are not been resolved before that. So it'd be the oral hearings on any state assessee appeals.
Yeah,
And for the last 3 years, how many cases have come forward?
two.
Two, is Mr. Reisinger still sitting behind me?
I mean, I don't want to schedule a whole day for
Right.
potentially 2 or no appeals.
But
I'd rather just do it all
last year
together.
was 6 hours.
Yeah, it's.
Oh,
it's a
6
big-
hours?
Get the
Okay.
big packet, I think, is it in May, with all the stuff, and then, and it's something that the controller has to vote on? One or the
And
other?
her schedule is cleared for, we set the values in May, her schedule is cleared for May, and then we generally hear the hearings in December, and her schedule is cleared for those days, because just like everyone else, that's how we
Right.
plan.
So I think we could have too much for just one day
It
in
could
that,
be.
because you got the FTB as well.
Yeah, last year we had 2 oral hearings, the prior year we had 1, but they can be lengthy.
Okay.
Yeah, it's a lot of properties, so, you know, there may be some other appeals. What about the 12th and 13th? And we can determine whether we come in the afternoon of the 12th?
That's fine.
Can we
Or-
wait, Madam Chair, because
Sure.
I don't have the controller's schedule, so I don't know about the 12th and the 13th. I know that she's available on the 11th for the BOE meeting, she's available on the 13th for
Ma-
the FTB meeting, but I don't know anything else at this time. I'm comfortable with moving forward with our annual meeting with the assessors on the 13th in the morning time.
Okay, the annual meeting with the assessors, that's fine with me, on the 13th in the morning. Then there's an FTB right after that. And then, so the meeting now that Ms. Richmond will verify is that we can all meet on the 12th as opposed to the 11th.
And I also need to mention that Mr. Horton is not available on December 12th through the 14th.
Oh,
So then scratch that, then we're back. to
okay,
the
so
11th.
what, let's just
I
leave the agenda.
can make the 12th,
Okay,
so.
Okay.
okay.
So let's just have everybody verify with their schedules and with the controller, and so this got longer than I had anticipated, but it's tough with
Okay,
schedules.
So we're holding the 12th right now.
We're holding
And
the
13th.
12th right now and the 13th. We are scheduled for the 11th. Joanne Richmond is going to get back with everybody and the controller and be sure that we can do that.
Okay.
Okay? Thank you. All right, thank you. So sorry.
And so our next item is K13, the annual meeting of the State Board of Equalization and the County Assessors, and this was to request to have the members.
It was approval of a letter, which we don't need your approval on now, because we will bring another one forth with the correct December meeting date. So
Okay, thank you.
it was just an eventuality, if the board adopted the April 18th date, that they can approve the LTA and we'd send it out. But we'll bring one later in the year.
So our next item is K14, approval of the fiscal year 2018-19 excise tax rate adjustment for motor vehicle fuel, which is the fuel tax swap.
Chairwoman Harkey, members, Dean Kinney, Executive Director. Last year, the governor signed Senate Bill 1, the Road Repair and Accountability Act of 2017, and Assembly Bill 102. Together, they require the Board of Equalization to determine revenue neutrality adjustment calculation one more time for the motor vehicle fuel for the fiscal year beginning July 1st, 2018. SB 1 immediately eliminates the annual revenue neutrality adjustment calculation for diesel fuel. The fuel swap model takes into account current statewide fuel prices and consumption to forecast for the next fiscal year, plus looking back 1 year to account for the over-under difference between the forecast and the actuals. For motor vehicle fuel, the fuel tax swap eliminates the general fund portion of the sales and use tax and raises the excise tax rate with the intent, by estimation, of raising the identical amount of revenue. For motor vehicle fuel, staff reviewed the calculated rate from the Department of Finance and recommends that the board set the excise tax rate for the period of July 1st, 2018 through June 30th, 2019 at 33.7 cents per gallon, an increase of 4 cents from the current rate of 29.7 cents. Therefore, I am requesting the approval of the new excise tax rate for motor vehicle fuels effective July 1st, 2018, which is required by current law to be adjusted by the Board of Equalization by March 1st, 2018. I'm available for questions.
Thank you. Members?
Oh.
I would just say I've never voted for a tax increase on gasoline for my constituents. It hurts them and hurts, I think, the working people of this state a lot. It's something that's directly passed on to them. So I will be voting no.
Madam Chair,
Yes, Member Horton.
I need some help understanding how, I understand how it works. I understand the fuel tax swap in 2010, the efforts and the balancing of the budget and why it was done, and the whole transportation fund equation. SB 1 seems to add another variable to this, where SB 1, effective, I believe, November of 2017, added another 12 cents a gallon to the gasoline tax and another 20 cents a gallon to the excise tax. With those increases, are those increases included in the projection, given that the overall effort or the intent, as I understand it, of the fuel tax swap was to keep the general fund whole and of course to be able to shift funds from the gas tax fund as opposed to the sales tax, so that you could, it would have a greater benefit in balancing the budget without going into all of the detail. But how does SB 1 affect this now? Affect the computations and so forth? Second question is that did the Board of Equalization, the BOE, make these computations, or the CDTFA make the computation and Department of Finance made their computations, and the board compared those and decided based on what? I want to know that this was the number that they would ultimately settle on. The other variable that gives me a little bit of pause is that in 2019, the gas tax will go up again to 47.3 cents. So there's a significant increase in the tax. And the gas tax is somewhat regressive in nature by virtue that if you own a company, you're able to write it off. And you work from home, there's very little charge to that. But for those that fall into the category of poverty and that are challenged somewhat,
Working people.
that are sort of pushed out into the suburbs in the first place in order to be able to afford housing, now the cost of them driving to work has increased significantly. So help me sort of
Mr.
see the equity in this.
Mr. Mark Durham, the Chief of the Research and Statistics Unit with CDTF, is here. We got permission for him to come up here and address this.
I mean, I appreciate Mark, and he's a very, very talented individual. Whom from the BOE has looked at this?
We had a meeting, we met with CDTFA, and our research person was also in the meeting.
Is our research person present?
I don't believe he is.
I didn't see him, no.
Okay. Hi, Mark.
Good morning, Mark Durham, CDTFA Chief of Research. So your questions, first off, what we do is we take the calculation from the Department of Finance, and they forecast what the price is going to be, for the next 18 months. So they have to forecast out 18 months.
18 months going, I mean, I'm asking these questions for the public that's listening in. 18 months going forward.
Forward, correct. So when they look at that, they look at the price, what they think the price is going to be, forecast, and they have a unit over in the Department of Finance that does that. They also look at the gallons. And price is going up, gallons are going down. So when you take those two factors in, we have to, like Dean was saying, you have to look at the revenue neutrality because the sales tax has been eliminated. So with that, there is an increase of 4 cents for just the excise tax. And the only thing that, so SB1 has nothing to do with this excise tax, the fuel swap. It's completely separate.
But it will have something to do with our constituents who are paying at the pump, and that's kind of what I'm looking at. I mean, they're going to pay more at the pump because of SB1. Now they're going to pay more because of this flipping or this forward scoring, so to speak, of what the anticipated revenues are. And in fact, if people are buying less gasoline, that means that it's doing what the state intends, which is to drive less or to go to electric vehicles, which is all just this spiral. And what it leaves is the people that can least afford it paying more increases. And I know this is not up to you, but I'm just saying that this is, it's a very fatally flawed policy, I think, for those that like Member Horton said, that are, commuting and working and probably have the least fuel-efficient cars. It's a tough burden, so.
Mark, here's where I need to sort of understand. I understand the mechanics of it. It's the equity of it that I'm having some pause. The intent of the legislation, as I understood it, was to fill some gaps in the budget. And so this was done in order to be able to address other policy-related matters, education, so forth and so on. But the tax on the gasoline has been raised significantly, and the tax on the excise tax has been raised significantly. And so theoretically, the net income to the state is going to go up significantly as they project it. And so are you saying that irrespective of the revenue, the increase in revenue that the state is currently going to receive, as a result of the projected revenue that they're currently going to receive as a result of SB1, in addition to that revenue, we're now going to add on this 4 cents, and they'll receive even more. So the intent of the legislature, from my perspective, was to solve some problems that it appears SB1 has addressed and solved.
That I'm not 100%, well, when we get into the specifics on SB1, what SB1 actually covers, and what all the programs that goes to, that's completely separate from what this excise tax is. So if we didn't have SB1 at all, and we did the calculation that we get from the Department of Finance would also show the 4 cents increase. They didn't look at SB1 when they did the excise tax.
Yeah, we know that.
Correct.
We're
So
very
it's
aware.
really a question I can't really answer. I mean, we're just, like I said, we're just looking at the excise tax, the fuel
I think
swap.
as an agency, we have to look at this holistically. I mean, the swap intended for us to look at sales tax, excise tax, and try to come out with a balance. That was the intent of the swap, is to bring a level of equity between the sales tax and the excise tax, the usage, the consumption, and so forth, to bring some equity so that you would have neutrality. I don't see neutrality when gasoline goes up 20 cents. with a cost of living, which means theoretically it could go up every year and just keep going up. Maybe they should have kind of, I don't know if it's fair not to take that into consideration. And I think I understand what your testimony is that SB 1, the increase in the gas tax and the excise tax under SB 1 was for other programs other than the excise tax program. So, yeah, I can't quite.
Square the circle.
This gives me pause. And as well as the fact that the BOE staff is not here to speak to how they came about their computations, and did they take that into consideration?
We allowed Mr. Durham to take the lead. Our person was in the meeting listening, but it was Mr. Durham who had done it. The person we had not done it in previous years, is my understanding.
So did CDTF provide this calculation under your standing memo of understanding, you're using their resources? So they were.
Yes, they
were
looked
like
at it as, in past years, as this has been discussed many times before the board, and I think 2 years ago, the decision was to go with the Department of Finance's estimate that they do for the governor's budget in December as to preparing it. And we looked at, Mark and his group looked at that, and it all worked, what they had is correct. We also took a look at what we would do as we'd done prior years, not the last two, because the board decided to go with finances projections. I think the discussion is, well, they have units that do all these projections and that they have more expertise, so we'll go with finance. That was the board's decision 2 years ago. But we looked at it as we had prior to the prior 2 years, and I think we would be 0.7 cents higher.
Correct.
So
We would be,
so the number that finance set
is lower than what we would if we calculated it today,
today,
with 2 months more of data.
but it's higher than what we set last year?
Correct.
Correct.
Based off the same calculation that, we're not changing the calculation. The only thing we change is the variables, because they're going up and down. The price is going up, gallons are going up and down.
Yeah, this is the same process that I've objected to year after year.
So
It's flawed to begin with. And so our staff is trying to follow direction, but that direction was not unanimous from this board because I've objected to it every year.
So what's the consequences if we don't set a rate, Chief Counsel?
So if we don't
Remains the
set the
same.
rate, then at this point, it would be automatically stay the same, right?
Right.
Yeah. Part of the problem is, in my discussions with Mr. Durham on this, we're doing this looking back, as I understand it, right? This is
going back, well, this is part of that. This calculation looks
We're
at
basically
the
guessing
true-up.
what the future's going to
And the
look like
forecast.
based on past information. And typically, we don't have, in the future information, we don't have knowledge that tax is going to go up 20 cents and then on gasoline, then it's going to go up, another 16 cents or so on excise tax. And that, if I understand the testimony, that wasn't taken in consideration in the computation. And now I'm hearing that the BOE staff would have recommended a 10-cent increase, or
No, it would be 0.7 cents higher than what finance calculated,
Oh, okay.
based on
So it'd be-
our 2 months more of data.
So let me clarify. What I meant was, my understanding is each year previously, this board, based on the information we got through Mark's group, which was then part of BOE, and finance, from that data, we projected an amount. So what happens is, at this point, we're looking back to see how that projection did. And at this point, the results of finance's analysis is that projection was low, which is why it requires a 4 cents increase.
Part of the 4 cents is looking at, we call it the true-up. So part of the 4 cents, 1.3 cents of the 4 cents is the true-up.
Not to interrupt you, Mr. Durham, but I understand the true-up. I understand the swap I get it, you know, and I've always voted for this because I've always read the legislation, and the intent was to create a neutrality. So at the end of the day, the taxpayer theoretically wouldn't pay any additional taxes, even though the excise tax may have went up, the rate may have went up, because over a long term, the sales tax was down, and so the net effect of them would be zero. But the things that we sort of take in consideration is the impact on the market, supply, demand, things of that nature, what the various marketeers are going to do. And they're starting to, things are changing out there as a result of that spike in the gas tax from SB1. And so it changes demand. It changes usage. And not to take that into consideration when, in fact, demand and usage is one of the variables in the computation, says that the computation is off, in my mind. So, anyway.
They don't.
The other part, let me just say, I really didn't get a thorough briefing on all of this from staff, and the information that I did have seems to echo the testimony that these other variables were not taken in consideration in the computation, and I need to sort of figure out whether they should have been, and how does this fit into the equity and fairness equation? Whether it's equitable and fair to the 8 million people that are living in poverty today. You know, the 1 in 5 children that go to bed starving every day. Those are the folks that I have to be concerned about when we start raising it and determining whether there will be a wash. Well, there will be a true-up in the preceding 18 months, giving the other variables that were not taken into consideration.
So to address a point that was raised, I have not analyzed what happens if this board doesn't vote on this particular item, but from a fiscal standpoint, as I understand it, it would create a hole, so that we would be under collecting. And then my understanding is this board is not going to be doing this next year, but the true-up would be even larger. Is that fair to say, Mr. Durham?
Correct. Mm-hmm.
It could be or it could not be. It depends on what the governor decides to do. This is the governor's plan, and this is the legislature's bill, and they also passed SB1. And I don't think that. I mean, quite honestly, we're not dissenting with staff here. I'm not dissenting with staff. I'm dissenting with the whole policy and the process. And I think Member Horton makes some great points that it affects those that are, need the help the most, and everybody else too. There's a lot of decisions, and as I understand it right now, the state budget's in a surplus. So I don't know how anybody can justify increasing more gas taxes. I mean, these are working people. These are people that go out every day and try to earn a living here in California, and this is a very regressive tax. And so for those reasons, and also because it's just not an equitable formula, I have never supported it, and I'm not going to support it now. So I apologize, members, but that's my point. Thank you.
What was the rate last year?
29.7.
I'm sorry?
29.7. And we're recommending a 33.7 cents per gallon.
Okay, members, do I hear a motion?
Move to adopt staff recommendation.
Is there a second?
Second.
There's a motion, a second. Objection? Call the roll,
Chairwoman
please.
Harkey,
No.
Mr. Horton,
No.
Ms. Ma,
Aye.
Ms. Dowers,
Aye.
2-2, motion fails. I think it stays the same. Thank you. If the legislature wants to adjust, wants to raise gas taxes again, they can do it.
Well, let me be clear. I don't see this as a raising of gas tax. And I never have. I see this as a neutrality, truing up, and so forth. However, the fact that staff has said that they did not take in consideration the impact on the market as it relates to the increase from SB1 gives me pause and consideration. And possibly we can have some conversations about how that fits into this equation from an equitable perspective.
Okay.
And I think, just to chime in, next year, the board no longer has to take a vote on any of these taxes, and we've taken the position that we are reviewing the Governor's Office of Finance's calculation, and if there was any significant change from when he issued his January budget to today, that was kind of our job. I think we're in a different situation because they changed the calculation. It's not the same that was under the fuel tax swap. The legislature passed it, the governor passed it. I don't agree necessarily, with the increase or, that we have to vote here on the board, because I don't think our role is the same as when we initially were assigned to, true up or ensure revenue neutrality or verify that the governor's office numbers are correct. But in my opinion, the legislature passed it, the governor signed it. It is what it is. So that's my vote.
Thank you. Okay, members, I guess next item. Mr. Kinney, are you off the hot seat?
I am.
Okay.
And I'd like to thank CDTFA management for making Mr. Durham available for the discussion.
Yeah,
Thank you.
One more, and then I'm going to be quiet.
Yes.
I had it in my notes earlier. You said something about we have a new TRA, Ms. Thompson?
Yes.
I'd like to say welcome, Ms. Thompson. I'm looking forward to seeing all the great work you're going to do as the BOE taxpayer rights advocate.
Where is she? Is she here? Oh, well,
that's
come on down. Say hi.
Come on down.
Excellent choice, by the way.
Thank you, honorable board members. I appreciate it.
My goal is to see that you are staffed up because it's really an important position. So I would hope that, our taxpayer advocate fulfills a very important role to the people in our district and also to facilitate the board members' staff with resolution to issues. So welcome aboard. Thank you so much. Let us know what you need, and we'll try to make the requisition for same along with Mr. Kinney.
Well, I don't know if we can make the recommendation, but
We can. We can make it up here.
do you have staff?
I have one person that actually has continued from the past taxpayer rights advocate office, Mark Sutter, who is my senior staff. And then I will be sharing an office technician with the executive team as well.
Okay. Any legal support?
I think that they will still be available.
Yes, sir. Legal's available and supports the Taxpayer Rights Advocate's Office.
I'm sorry, was there a question for legal?
No.
No.
Just want to be sure she's covered and
Right.
she's getting the staff that she needs, because I know we resolved, 400 or 500 taxpayer issues in our office just over the last couple of years. Small things, and some of them we went through the taxpayer rights advocate, but many of them, were researched and resolved. And I think that, I want to be sure that doesn't slip through the cracks, because people do have, a tax concern is very frightening and important to anyone who has it. And I've always found, too, a lot of people are not willing to come forward and admit they might have a tax issue because of embarrassment. So I think it's really important that they have an open forum and discussion, that they know that somebody's out there advocating for them. Because it's tough in California. We have a lot of taxes and a lot of different laws, and people are just, like I said, they start up new and they get stuck, and like a lot of people don't want to admit. And so that was biggest part of our job, quite honestly, was going out and letting people know who we were, what we were doing, and to please call us. So, I look forward to working with you.
Yeah.
I have an extensive background in property tax, and am very committed to customer service, so.
Good.
Excellent. Let me share the change in dynamics as to how board members sort of engage in this taxpayers' rights process will, at least in our office, will cause us to shift a lot of the constituent matters to the taxpayers' advocate's office, far more than they've received in the past. And of course, the publicizing of the role of the Board of Equalization is causing many more assessors to engage members. And in a natural evolution, it just happens to be the point in time in history where property tax matters, as far as the rulemaking process and all of those, are now being taken under consideration, irrespective of the changes. It's just we have not looked at many of these issues over a number of years. The other variable is that there were quite a few matters that were percolating in the property tax arena as it relates to Cal Tax and some of the others, the property tax assessors and so forth, that are coming to a fruition. And so that in and of itself is going to, I would anticipate, generate greater activity as far as the Taxpayers' Rights Advocate's Office, irregardless of the interpretation that the Board of Equalization is not representing property owners, which I, quite frankly, find hard to believe, but I don't think that's the perception of the general public who voted for these members, that there wouldn't have that level of representation. So I only share that to encourage Mr. Kinney to do what he can to maybe provide our new taxpayers' rights advocate with a staff of their own, so they're not sharing staff, in anticipation that over the next year or so, the workload will increase and the capacity will need to be there. Thank you.
Thank you. Okay, thank you and welcome. Thanks for joining us, and thank you, Mr. Kinney, for your testimony and for your updates. All right, Ms. Richmond, are we going back to square one?
Yes, we're going back to item C, public hearings. Item C1, property taxes, state assessees, presentations on capitalization rates and other factors affecting values. And we do have a speaker.
Thank you. Welcome. Please introduce yourself for the record.
So I'm Dick Reisinger, the State Assessed Properties Division. This is the first opportunity under board rule for state assessees and other interested parties to present comments to the board in a public setting regarding capitalization rates and other matters affecting state assessment for the fiscal year 18-19. I'm here to address any comments and answer any questions. I did want to mention that of particular interest this year is the evaluation of the potential impacts of the new Tax Cuts and Jobs Act of 2017. Significant reduction in the corporate tax rate and the limitations on the deductibility of interest expense may have impacts on capitalization rates and assessed values for state assessees. To what degree, it's uncertain at this point, but we are reviewing a lot of information on the changes in the capital markets, and we've met with many of our larger state assessees and with other state central assessors and to get their input. And I'm confident we'll be able to adequately address this issue in our 2018 values.
Thank you.
Hi, my name is Peter Michaels, and I'm here today on behalf of 40 state assessees, including local exchange telephone companies, inter-exchange telephone companies, wireless carriers, gas and electric utilities, independent electric power producers, railroads, petroleum pipelines, and natural gas pipelines. We have a similar agenda to the one Mr. Reisinger described, and we have been in frequent communication with Mr. Reisinger and his staff. We've met with Mr. Reisinger and his staff. We'll continue to meet with Mr. Reisinger and his staff. They've reached out to us, to their great credit, for our input on the impact of the federal tax legislation that was signed into law at the end of last year. And it's been a collaborative exercise with the board staff among the companies I represent to make the necessary adjustments based on the new law. We've also discussed with Mr. Reisinger and his staff the impact of some of the highly publicized natural disasters in this state in recent years, and unfortunately there will be more natural disasters, in all likelihood fires and floods, so we're addressing valuation-related issues and risk-related issues with Mr. Reisinger and his staff as well. And finally, marketplace dynamics, the energy space, the energy segment, energy production, whether it's solar, wind, conventional, combined cycle power production. It's dynamic economically and technologically, likewise, transportation and telecommunications. So we're looking with Mr. Reisinger and his staff at the economic dynamics of the companies that you will be adopting values for in May. But so far, so good is what I want to say.
Thank you. Members, any questions? Any comments?
To both parties, Madam Chair, what are your views on the current method of determining economic obsolescence?
Well, it varies from industry to industry, and it varies within industries. There are subsets within industries that are losing market share, and, for example, local exchange telephone companies is probably an example where there would be no difference of opinion with Mr. Reisinger. There's economic obsolescence because the property itself is not less valuable, but the customer base and the economics of running the business are way different than they were when that property was purchased. So the property is suffering. It is less valuable to a prospective purchaser, even though its actual inherent value is not lower. So local exchange telephone's a good example where they've lost 75 or 80% of the customer base they had 10 years ago. We all had local phone service 15 years ago, and now very few of us do, certainly very few under the age of 40. So that would be an example, but if you looked at wireless, you might have a very different conversation where there's growth. There's a lot of technological advancement, and that could lead to functional obsolescence, perhaps. So it depends, in my view, on the actual market segment of the industry that we're talking about. In some instances, yes, it's appropriate to make an adjustment for economic obsolescence where the property, through external forces, whether it's court rulings, whether it's regulatory change, whether it's technological advances, the property actually is less valuable. And there are other instances where that's not the case, even within separate markets. So Mr. Reisinger, I'm sure, can speak authoritatively on the subject.
Well, I think it's well established on the methodologies that are used to measure obsolescence. We have income shortfall methods. We have underutilization methods. We have RCN, replacement cost new studies. I think the critical thing in all these methodologies is the data and the information that's utilized in these methodologies. I think the methodologies are all solid and they're used around the world. It really comes down to getting the appropriate information to make those models and methodologies lead you to a proper conclusion.
Part of it will be the experience. It's the mixture of the two. Mm-hmm. And when you end up mixing economics, when you end up mixing the two different computations and why you do so and why you don't is where the dispute sort of comes into play.
We have not had that problem. Certainly with the State Assessed Properties Division, I think we can delineate, at least for our own purposes, functional obsolescence, which has certain characteristics, and economic obsolescence, which has different characteristics, and they're not mutually exclusive, or they're not. They can both exist. But personally, I don't recall.
You're generally in agreement. I'm actually speaking of the entities that come in and they're not in.
Well,
You know what I mean?
Yeah, I think you're probably alluding to, we've had the oral hearings the last couple of years relative to the power plants.
Right.
And really, we've narrowed it. We have 40, this year we have 47. I think we had 42 last year. And we really only had one appeal of those 40 assessees. It got to the board because we couldn't resolve it with the assessee. But I think our methodologies are sound. I think we've narrowed in the past we had a gap between like our cost approach and our income approach.
Right.
And we've worked really hard in the last couple of years at narrowing that gap so that everybody's more comfortable that both value indicators are in the range of reasonable value. Right.
Yeah, I want to commend the department. They really have stepped up and stepped forward based on this board's recommendation that they consider these items. It was a very thorny issue, and I think they've done a really good job of trying to be sure that those assessments are lining up.
I agree. The disasters that occur, Mr. Michaels, tell me how that affects your client.
okay, and just as a quick addendum to what Mr. Reisinger said, many, like a high number of the similarly situated electric power producers, there's one outlier.
Yeah.
I represent most of the other ones, most of the other ones. And we work very closely, and there's a spirited give and take, and we certainly establish, our presence. We make our views well known to the staff, but ultimately we find some common ground. But we're not necessarily in sync from the first step. Natural disasters. So what has been highly publicized with the recent fires, as recently as yesterday, with PG&E here in Northern California, the Napa fire, with the floods down in Ventura, Santa Barbara County, and what is likely to happen. This is also true of several other high-profile property units, notably including the San Onofre Nuclear Generating Station in San Diego County. There's been an outcry for the investors of these utility companies rather than the ratepayers of these utility companies to bear the costs of these natural disasters. So the theory goes, if PG&E is at fault, or if Southern California Edison is at fault for the fires or the floods, and that a court would have to decide that, then the ratepayers should not have to pay the damages. Those damages should come out of the pockets of investors. Well, if that's the case, then an investor, a prudent investor who's considering buying PG&E or considering buying Edison or any of these properties is going to adjust the purchase price because the buyer's going to say, hey, look, I'm signing up potentially for some heavy-duty damages here, so I'm going to put that into my calculus in how much I'm willing to offer. And I think that's absolutely true.
So it becomes a value indicator.
Well, if we're looking at the fair market value of property from the perspective of a prudent investor, a prudent purchaser, and a prudent seller, the purchaser is going to offer less than that purchaser might previously have offered if that purchaser is assuming liability for natural disaster damages.
Now, are you anticipating legislation along those lines?
Well, the PUC is
court
very
matter.
active, and the courts are very active, there has been talk about legislation, but, we're looking at property, the fair market value of property here. We're looking at the assessed value of the property. So regardless, I would say, of legislation, is the property, in the eyes of a prudent investor, worth less than maybe it would otherwise be if that investor is on the hook for disaster liability. In the past, those liabilities have been borne in part or in whole by ratepayers.
Yeah,
With
so it
great
was-
debate, by the way,
Yeah.
over the years. Yeah.
What's that?
No comment. Yeah, I'll go ahead. Very good conversation,
question,
but I understand what you're saying, that, there may be some litigation that the companies are responsible or have to bear the cost. But wouldn't, at the end of the day, the rates will increase, so the individuals, the ratepayers will still be bearing that cost?
Well, who's paying the damages? The damages are coming out of the pockets of the investors.
But eventually won't the ratepayers' rates go up because of it?
The PUC governs rates. The PUC has the final say. The PUC dictates rates that PG&E is permitted to charge. PG&E doesn't decide. The PUC does.
But
Edison
PG&E can
doesn't
go
decide.
back to PUC and ask to increase the rates.
Of course they can. They've also asked for the costs for these natural disasters to be borne by ratepayers. That didn't go over so well.
No.
So
I'm seeing an increase.
ultimately, the last word on rate making is with the California Public Utilities Commission.
Right.
So from the BOE perspective, are you guys considering that for this upcoming value setting?
Well,
Well, they'd have
Or do you have to have actual,
we pretty much rely on what the CPUC approves. You have to remember, for these large companies, these rate-regulated companies, the value is based on historical costs, and they're going to get a return based on what the CPUC allows and what their cost basis is. So that's why when you look at our valuations for those big utilities, those rate-regulated utilities, that we rely 75% on the historical cost to determine the value. Now, we have spoken with all the four major utilities, rate-regulated utilities, and they've all expressed the same concern, so hopefully they'll provide us with some information. I think it may be difficult to reflect it in the current year's valuation, because I don't think we're in a position to set the precedent on what the CPUC is going to allow and what they're not going to allow. So I think that maybe it'll be resolved in the next fiscal year. It's really difficult for us. We determine our rates based on what the CPUC has approved and what's in the marketplace. Now, the marketplace may have reflected some of this at the end of the year, this increased risk, and that would be reflected in our cap rate study, but probably not to the full extent that the utilities would like to see it.
But, to Mr. Reisinger's credit and his staff's credit, they have reached out to us. We've discussed it collaboratively, and we've jump-started a discussion about it. And there's merit on both sides, and there's a middle ground we'll find.
that's good. Nice to hear that you guys are working together.
We try.
And just as an aside now, Chair, I'm deviating a little bit. Tell me how the federal tax law impacted you.
Okay, well, on the one hand, the rate just dropped by 14%.
Right.
So in theory, you're going to earn more money.
Right.
If you're a rate-regulated company, such as the ones we were just talking about, and this is the case across the country among many companies, I'm not vouching for any of the big ones here in California, because don't know for sure. The big utility companies that are rate-regulated are actually taking the initiative and going to the public utilities commissions across the country and saying, hey, you've got to lower our rate of return. You've got to reduce the rates that you're setting because we're going to be making more money. So we see the writing on the wall. So there are utility companies that are preemptively approaching state public utilities commissions and saying, we see that our earnings are going to be going up, and therefore we think, we should talk about what kind of an adjustment to make. It's a preemptive strike. There are, under the new law, limits that didn't previously exist on interest, the deduction of interest. So that is kind of the flip side of earnings going up, because you can deduct less interest now. This is true for many, but not all of the companies that you assess. There are views that the costs of capital and costs of debt will be affected by the tax law change. And I think if we're looking as of January 1, there's no way of knowing what, in fact, that impact is going to be, because the bill didn't get signed until December 27. Right. But if we're asking ourselves, what would a prudent investor be thinking on January 1? Well, that prudent investor would say, hey, the tax rate's going to go down. So we're trying to balance that.
Any anticipation of offshore income coming back into the states?
Mr. Reisinger can address that too. That does not seem to be an issue for these companies. They're really California grounded. All the infrastructure, all the assets, all the workers. There's nothing outsourced by the companies you assess. Now, many of these companies have subsidiaries or affiliates that do business in other places, other states, but the properties that you assess are grounded here in California. So Mr. Reisinger could maybe fine-tune what I'm saying, but I don't think that's an issue for state assessees.
No, I get it. I didn't think so either.
Yeah, we're valuing the property in California.
Yeah, I didn't think so.
I would make the one comment that I don't think anybody expects that the utilities themselves don't expect it. We don't expect it. The PUC doesn't expect it, that they're going to get some windfall from the reduced tax rate, income tax rate. All the major utilities we've talked to, they're already working on projections and analysis, expecting the PUC is going to require them to reduce their rates to ratepayers to reflect the fact that they're paying, significantly less in income taxes. So,
right.
That's interesting.
Thank you. Just thought we should have the discussion for the
Yeah,
public.
it's going to be a balancing act, and there are certain elements where there's going to be higher revenues, and there are going to be certain elements where there are higher costs. So we're working with Mr. Rice.
That's interesting. So will the PUC make announcements on their website that we could track?
Oh, I'm sure
they'll make decisions at a public hearing, and there'll be plenty of press about it.
We follow the webs. We follow all of the rate cases.
Yeah.
They're all public records. So.
Okay.
Well,
I have so many things going on in my world. If anyone would like to shoot me an email when an announcement is made, I really will appreciate it.
There'll be a series of announcements, because PG&E is going to have a rate case, Edison's going to have a rate case, Southern California Gas, and so forth. There are a whole bunch of.
Boy, this could be fun, right?
I would like to.
Depends how you define fun.
You don't have to, but if anyone wants to, why style with that?
Of course.
I would love to see it. Yeah.
Well, let me-
I'll probably see the press anyway.
Well, are we allowed, Mr. Reisinger better do that, because it wouldn't be appropriate for me to
Yeah,
have an
this-
ex-parte communication with you.
Oh, you can. But anyway, we need to clear that up, if that's how people actually think. But legally, we need to issue some kind of memo or something. But let me just commend you, Mr. Michaels, for the work that you continue to do on behalf of your constituents, and particularly in this particular case as it relates to the federal tax law. It's quite pleasing to know that folks are coming forward in anticipation of the benefit and anticipation of trying to equitably share that benefit with the ratepayers. Appreciate that.
Thank you.
Thank you, Madam Chair.
Thank you. All right. Mr. Reisinger, you're off the hot seat, I think.
Not yet.
Not yet.
Not yet?
I'm off the hot seat.
Oh, no mas, huh? Ms. Richmond?
And so our next part of the public hearing is for the private railroad car assessee presentation and factors and procedures affecting fiscal year 2018-19.
Again, I'm Dick Reisinger from the State Assessed Properties Division. This is the first opportunity under board rule for private rail car owners to present comments to the board in a public setting regarding factors and procedures affecting taxable values of private rail cars for fiscal year 18-19. I'm here to address any comments and answer any questions.
Madam Chair?
Yes.
With all the discussion on the railroad issue, the assessment and so forth, in the legislature, no one came forth to express any thoughts?
No, we worked with we've been working with the major railroads in developing our cap rates.
Okay.
We've had discussions with them about that, but we haven't had any valuation issues with them in the last few years. And the same, private rail cars is pretty straightforward. It's just a calculation, and we haven't had any issues with them for years.
Okay.
Everybody's in agreement.
Thank you.
Okay, thank you very much.
Thank you.
Next item?
Our next item for today is closed session. Would the members like to take this item up last?
Yeah, we can do that last. Is that okay with the members?
Yes.
Okay.
Okay, so our next item is item M, board member requested matters. Item M1 is to establish constitutional and related statutory matters as a standing agenda item, and we do have speakers for this matter.
Thank you.
Someone explain what it is first.
Yeah,
Member Horton.
This is Mr. Horton's item.
Thank you, Madam Chair. Traditionally and historically, the board has been in a position to hear matters of concern from the constituency well before, as Member Harkey indicated, they mushroom. The other problem that has occurred is that the public lacks the ability to hear from the board as a collective body as to what our views are, what our concerns are collectively, because of the notion of ex parte communication and so forth. But even when ex parte communication was in play, the only way that you could address the collective body was in a public venue. And so I believe that the lack of these forms of communication limits the level of public engagement in the discussion, public awareness in the discussion, limits transparency in the process, as well as the overall accountability to the board as a body. So what the recommendation is to say when these issues or topics come up, that the board members should be in a position to hear collectively from the public as to what their concerns are, as well as from the quote-unquote interested parties, as well as from staff. We have no mechanism to accomplish that currently. And so the desire is to have staff develop some process that allows us to do that. Our chief counsel spoke to this as one of the means in which to accomplish that objective and to address the concerns of members about being able to participate more actively, more engaging in the process, to the concerns expressed by Caltax, and addressing some of their concerns, letter to assessors, and bringing about a level of uniformity in how the various assessors are assessing property tax and the decisions and recommendations that are going forward. So really, it's just, the goal here is to increase transparency, increase public awareness and participation in the process. And that's about it. That helps.
Thank you. Yeah. Go on, Member Munn? No. Okay. All right. We have two speakers, it appears. We have Mr. Chuck Leonard, President, California Assessors Association, if you'd come forward, and Mark Aprea, Principal Aprea McKaylee, California Alliance of Taxpayer Advocates. Mr. Leonard, if you wouldn't mind beginning.
Okay, thank you for your time. I think from my perspective as an individual assessor, and I believe assessors in the association appreciate the need for you to receive public input. And I think this matter creates that door, which was, I think, what Mr. Horton's intent is. I think the concern that I have, if anything, is just that it be implemented in such a way that your staff is still involved in the process, that we're following things like the manual that we have for interested parties meetings and those things that ensure that issues get fully vetted before decisions are made.
Thank you. Let's let Mr. pray, and then I'll open it up to conversation.
Madam Chair, members of the committee, for the record, I'm Mark Aprea with the firm of Aprea and McKaylee, here on behalf of our client, the California Alliance of Taxpayer Advocates. It's a statewide trade association representing property tax agents. And we want to express our support for Board Member Horton's motion. It has been 18 months since we first wrote to you. It has been 6 months since this board unanimously directed staff to initiate an expedited interested parties process to address the issues that CADA has raised with, regarding property tax issues and property assessment processes with the Board of Equalization. There was one meeting in that 6-month period of time. It was on December the 18th, and at that meeting, staff indicated that we would have a report sometime in February and a meeting, a follow-up meeting in March, albeit it was not an interested parties meeting. It was more of an informal gathering, not the interested parties process that you had directed. CADA is prepared now, as it was in September of 2016 and at all times subsequent, to work with representatives of the California Assessors Association, the California County elected officials and clerks, the Board of Equalization staff, and BOE members to address the issues that we've raised with you regarding the equalization or the uniformity of assessment appeals and assessment appeals processes. In fact, within the last few weeks, CADA has developed a standards committee. Mr. Peter Michaels is a member of that standards committee who will help us in developing not only our policy but providing some assistance with regard to our advocacy. The bottom line is that given in 6 months we have only had one meeting, by what standard is that an expedited process? We therefore must ask the board respectfully that you set a schedule for this process to move forward, and that you require that this matter be brought before you to resolve these issues for a vote before the end of this calendar year. I am concerned that the board failing to set the schedule and a deadline, that we will be here a year from now with very little progress to show. And I think that the past is a prologue to the future unless you all choose to intervene. And so it is with that that I again respectfully request that this board set the schedule and that you ask that these matters be brought to you for your decision before the end of this calendar year.
Thank you. I just would like to say we had a very detailed list, and it shouldn't have been that complex. I think we even had some solutions. And I know might be a little dissension among the assessors, but I didn't think there was that much on some of the issues. Everybody seemed to agree. LA was leading the charge with the letter that was uniform. There were other issues bringing up, and I think this board decided that maybe we'd circulate the letter from Los Angeles to the other assessors to see if they could buy on, and then that way we'd have everybody in cooperation with it, because we're just trying to create some uniformity here, and I just don't know why that dropped. I'm not sure, but I know that's one issue that I recall that we requested, that it be just resolved. And so I support Member Horton's suggestion here in his process, and I think that if we can get these things on the agenda, we can get them done. We do have board member staff that's more than willing to do research and assist in the process. I know that sometimes the property tax staff is not really, you know, they're still staffing up, but I know I have some professionals, and we have some professionals still on the board member staff that could assist with, you know, trying to streamline this. And, you know, because we did have this request. We had a full little booklet. There were 3 items, I believe, 3 or 4 items that were requested by Mr. Prea.
Yes, ma'am. There were the issue of 441D requests. There were also the issue of hearings being capriciously denied, and that hearings were extended for long periods of time, therefore, from our point of view, denying the taxpayer their right before the Assessment Appeals Board for a hearing.
Yeah, I recall that too, and then there was uniformity of the other processes. So, you know, I would like to support what Member Horton's request is here and establish as a standing agenda item. I would very much support that, and I do want to. I know that like I said, there are concerns that the staff doesn't have. They're not really geared up to be doing all of this, but I think that we could, as board members, submit the items and then run them by Mr. Kinney and see if we can't do some kind of a unified approach to getting some of these things forwardly to research and whatnot, because I don't think that Mr. Kinney is staffed up to be dealing with some of these items. And they are our request, and I think we should have, our staff should be putting something together for the rest of the members to review, and we can make a decision up here. Would there be any problem with that, Chief Counsel?
I would have to get some more details, but in concept, that seems to be appropriate to do.
Yeah, we could draft a memo and send it to Mr. Kinney's office, and then have it run by our chief counsel, and then maybe stick something on the agenda and just kind of get these things done. I don't think they're that big of hurdles. I think one of them may require a little additional discussion. As obvious, it seems to be a sore point, but I think there's at least a couple of these items we could tick off. Yes.
Madam Chair, if I may, let me share that I believe that the process of staff engaging independent of this body needs to be a strong, supported process without members' involvement necessarily. So I'm actually supportive of not having us involved in that process. The challenge is that the issues that have been percolating have not had an opportunity for this body to hear those issues and to give direction to staff as to how, from a policymaker perspective, we believe the policy should be adhered to, or if there is a direction. The airline issue is one that comes to mind. The issue that Mr. Prea just set forth is an issue that there's no venue currently to have that discussion. The public has been excluded from the process as a result of the change in the legislation until such time that the issues that go through the administrative process matriculate up to the board members, but the decision as to whether or not, from a policy perspective, these matters should be expedited. These matters, instead of having a letter to assessors, that they should move into the rulemaking process, because it's not just germane to a particular assessor. The issue under consideration is a broader issue, and that's a policy decision. That's not necessarily an administrative decision, and we are not privy to that. And so the public participation is de minimis. And I don't know about other members, but I'm hearing from my constituencies that they don't have a voice. And quite frankly, it's concerning. The assessors are looking for an opportunity to, the assessors in my district, an opportunity to have those dialogues with the decision makers, at least to share some of the issues that they may be, they would like the board to take under consideration. And then if the board makes a decision to take it under consideration, then the board can move it into a more methodical process that drills down on those issues. And that is not to say that every issue that comes before this body in a discussion, the board is going to collectively say that we believe that this should be, after consultation with legal, that this should move into the rulemaking process, that this process should be expedited, and this issue needs to be resolved, and set a calendar for it to be expedited, because that's a policy decision that this body should be involved in. So it is a preliminary process, similar to in the legislative process, where the legislature will go out and preliminarily conduct throughout the district informational hearings to hear from the general public, either about legislation that has passed or legislation that may pass. We have no vehicle in which to engage our constituency in that regard.
So just to clarify for the board members, there is a little bit of a limitation that we need to be careful about. Member Horton, you kind of touched on it in your comments, and that is the legislation has limitations on the board directing staff. But to the extent that you provide communications, there's dialogue, either with the public, with staff, or with others, that's acceptable. And I think that's kind of which it seems like you had in mind, Member Horton, with your M item. The other thing, as I mentioned in my previous comments, the board can always agendize an item for general discussion to get input from both staff and members of the public at a board meeting, and that is something that you can do as well. So
Right.
there are several vehicles that you have to achieve your goals.
That was my suggestion. I think we have a lot of very talented staff that are underutilized right now, and when we got divided, it was obvious that we had kind of an over amount of we were overstaffed in our board members and not so well staffed on the other side, in the agency side. That being said, the staff has not been reallocated, which they probably should be reallocated so that they can perform their functions as part of the agency. But they haven't not lost their mental capacities, nor their ability to provide information. And so if in fact a memo is sent, that is not a direction to do, but I would think, any executive director would probably appreciate that, put it on the to-do list and research it, have it researched. I mean, it's like we've got our hands tied every way to Sunday here, and we've got staff that nobody seems to be finding a place for, and they're working, and they're learning, and they're taking tests for, real estate issues. My staff is full speed ahead, and I can't hire the staff that I really need, and these people can't seem to find a position outside, and I'm just wondering why it's breaking down like this. So I have really good, talented staff still remaining on my staff that are trying very hard to get up to speed on the property tax area, because they have been applying and they haven't been getting jobs anywhere, and I can't believe it's because they're not able to be utilized. I think they're very much able to be utilized. I just think there's just kind of a breakdown in how we're processing, and I really do wonder if some of the way we're processing personnel requests and job applications is appropriate anymore. So I'm trying to give them meaningful assignments within the member's office that might facilitate the agency, which is short-staffed. And I doubt that any member sitting up here feels like their staff is being utilized to their full capacity or potential.
And that would be an acceptable use of member staff to the extent that they can augment the work that needs to be done. That'd be perfectly acceptable.
Yeah.
Thank you.
Well, point of clarification in regards to our chief counsel's comments, which I agree with, by the way. the intent is not to direct staff. I don't believe, the intent is not to change anything that hasn't historically happened in the past. Is that this collective body is to establish policies within their jurisdiction and to give direction to the executive director as to how those particular issues should be addressed. And so when a process is not working, it is not only the obligation of this body to share its concerns and give direction to the executive director as to how that process might be expedited, or whether or not it is in conformity with our constitutional duties to ensure that the rules are uniformly applied throughout the agency. Those are the issues that I believe should move through this process. And true enough, the public could probably call up the agency, you know, but good luck with that. So this provides an opportunity for us to hear from the general public. It's no different than what the legislature does when there's an issue of interest to the legislature. They, in fact, will go even one step further. They will actually conduct these types of informational hearings or public discussions throughout the state to get input from their constituency. The other thing is the accountability side. It kind of brings balance and equalization to the accountability. Everyone's going to be accountable if the public is going to be aware of what's going on. So there is always good in making sure that the public is aware and that the assessors have an opportunity to speak to us collectively. There's no other way it can happen except for in this environment.
Thank you. Members, now, does this require a... Yes.
I just have comments. Okay, we do agree that having some type of an informational hearing will increase transparency, and increased transparency is always a good thing. I'm still unclear on the process. Would Ray is written, I'm not sure that a member of the public or a consultant or someone can say, I would like for the board to have a conversation on X. And then they would present that through, I'm imagining somehow through the chair of the board proceeding, and then it will be placed on the agenda.
Well, from a recommendation perspective, only members, subject to the members' concurrence, is the question is how does this agenda get populated? Mm-hmm. The same way it has historically is that historically, if a member wanted to place something on the agenda for discussion, they would just simply ask that it be placed on the agenda. Mm-hmm. Chair would make an assessment, and then chair would go through whatever they think might be necessary in order to have a fluid, informative, productive discussion. We do want to get, so there is some level of, or need for some level of intellectual engagement. And then the general public would, if there was an issue, they certainly could have a conversation with a member, or they can have a conversation with the chief counsel, they can have a conversation with the executive director. The executive director then has a conversation with the chair, mm-hmm. and it gets populated through that type of process. And quite frankly, folks might just come and just say they want to speak to their elected officials.
Right. So with that being said, it's populating it on the agenda. If it's going to require resources, and if that's going to fall on agency, they're already short-staffed. I understand that the chair is saying maybe a member's office could provide the detail for us.
Yeah, I don't want this to become overly complicated. What I'm trying to do is facilitate the public that elects us and the taxpayers that are here, you know, asking for just certain process to take place, to be resolved maybe beyond 2-3 years. You know, or maybe before 2-3 years. I think that what Mr. Aprea is asking for has been around for a while, and that we're not getting any information. And I don't blame our staff. I think they're short-staffed. This happened to all of us like rather abruptly, and everybody's just trying to gear up. What I am saying is that I have qualified staff that can submit suggestions to go through the ED, through me, and then through the ED, and the ED can schedule or do whatever he needs to do. And then we also have this other item here that is board member requested matters, so we can put those on the agenda. But I just don't want to get stuck in that maybe we are directing staff. We're not. We're bringing up our constitutional responsibilities, and we're trying to bring things forward. And to the extent we're able to do research and provide that, and maybe it gets checked, or maybe it just becomes a discussion, I think that's what Member Horton wants, and that's what I want. I really want, I mean, this has become, it's becoming a bureaucratic nightmare.
Yeah.
And I want to be sure that the issues that are brought before us in earnest, I mean, they're concerns, and they're not, they're not unresolvable. They can be resolved, that we just kind of get a little momentum behind them. And I'm not blaming the staff. I'm not saying they need to kick it up. I think our staff can help facilitate the process, and then we can just get them scheduled on the agenda.
Yeah.
I don't think we have to make this a nightmare. It's not like we have more than one board hearing, and it's usually, a couple hours. This one went on a little bit because there were other issues on it. But I just think I don't want to renege on my responsibilities here, and I don't think the incoming board, whoever they shall be, is going to just sit back and let everybody just handle things for them. I can't imagine that. I know some of the candidates, and I can't imagine that. So I'm just saying I'd like to at least have a facilitated process so that we this is kind of our duty to get this thing organized before we get a whole new board coming in, and then the staff gets a whole new different set of instruction. It's almost a merciful approach on us to be sure that, because we understand what we do, we understand what our responsibilities are, we understand what our limits are now too, and I want to be sure that that's understood so the new board doesn't come in and start blowing it up, because they're going to be looking for ways to facilitate. Yes, Mr. Leonard.
If I may just update the board on Mr. Aprea's matter, there has been a lot of work that's been done on the concerns that were raised by CADA, and the assessors have developed some suggested language for 401D request letters, which has been circulated. There was a resource that was created for assessors with information about the appeals process, which was done subsequent to the meeting that was held with board staff in December. There was a period of time which the interested parties had an opportunity to provide comments and information on the discussion. It's my understanding that they're putting that into a matrix. Yesterday, I was given a tentative date, I think, for a meeting in the near future to discuss that matter. So there is movement on his topic.
Thank you. Mr. Aprea, do you feel like there's movement on the topic?
That's news to me about a meeting that's being
See, this is the
scheduled.
problem. We need to have this stuff come forward to the
And
board.
staff told you that there was no meeting that had been set. So I just want to set the record straight. I'm also interested to get clarification regarding Mr. Horton's memo. And I'm just, because again, I'm not, you used the term making this a standing item. So I wanted to get some clarity on that because let me back up. So when you all in August of last year set forth an interested parties process, and then that interested parties process did not emerge, and then there hasn't been any action other than that one meeting. And yes, there were letters that were submitted on January the 19th. There hasn't been any other activity. We haven't heard back from your staff, as we mentioned in the letter we sent yesterday, and we've, even though we've requested meetings with the Assessors Association, no dates have been offered by the Assessors Association to respond to future discussion. So the expectation was that we were going to have a expedited interested parties process. Mr. Horton indicated that typically, and I don't mean to put that on Mr. Horton, but he mentioned that that interested parties process typically goes 5 to 6 months. Well, here we are 6 months later, and we're wondering, where are we and what's the
Now
next
you're
step?
finding out there's been meetings and there's been decisions,
Yeah,
but you're
so-
not included.
So my point, however, is that I think,
Okay.
would be helpful for the board to be able to allow us to let them know what they should anticipate. Should they, as an example, be prepared to have a discussion with the board and with other interested parties at your next meeting on this item, so that we can, in essence, as we did at that meeting on the 18th, discuss with you what our concerns are and where we see not only where we believe there's been an abuse of power, but where there's been inconsistencies across the board. Now, we've submitted to you, and you all had, when we met with you in August, a number of letters that we thought provided evidence to that. But my hope here today is to come away with resetting what that expectation should be, and by when might we see some resolution. We may disagree on what issues should be resolved or not, or how they should be resolved, but right now, we are waiting for 6 months and we don't know where we're going. And therefore, that is what I'm asking of this board, is to provide us with some level of expectation. It was Mr. Horton's memo referencing a standing item that gave us some encouragement that, along with the interested parties process in parallel, that your staff and the other interested parties would be able to inform you as to how they saw things going. Clearly, my good friend from CAA and I perceive the progress in a different way.
Okay, Madam Chair, I really didn't intend for us to get into the weeds on this, but I do appreciate the discussion, because the discussion is indicative of the reason why the closed-door discussions that are happening behind closed doors now, that the members are not privy to, that the general public is not privy to, is just wrong. There is no transparency. Whether what's going on is, there isn't a level of transparency in the process that we need to somewhat provide. The staff work, as much as I appreciate and I am sensitive to the lack of staff as a result of some things that have occurred, that's not a decision factor for me. The decision factor is doing the right thing, and then we can't function based on the level of staff. If we did, we would almost have to shut the doors, because our staff is seriously understaffed on a number of different levels. We need a process, a format that provides public transparency, accountability, and engagement. It is a mere discussion that can occur on a particular topic. From that discussion, the members will be able to share collectively their thoughts and work with the executive director to have those challenges addressed. And as it relates to the issue brought forward by Mr. Aprea and the assessor, clearly there's a misunderstanding about here. And no matter what one side says and the other side disagrees, and they say, oh, no, that's not the case. So that mere disagreement is an inherent challenge. And so we can have that, ask the executive director to look into it, and then report back to us whatever resolutions he might deem necessary in order to accomplish the objective set forth by the board to expedite this matter, because it's been prolonged for reasons that I'm certainly aware of, but most of those reasons is a Cool Hand Luke reason. I don't know if you saw the movie where you had two prisoners trying to escape, and they realized that they had to work together. And the one challenge that they realized is what we have here is a failure to communicate. And so, and for me as a member, I just want to know what's being talked about behind closed doors. I just want to know, I want to be privy to those conversations, and I want my constituencies privy to those discussions to the extent that it doesn't impede the administrative process of you doing the work that they need to do, because I appreciate that as well.
Okay, so I will put forth a motion to approve the action to establish a standing agenda item for the board's monthly meetings regarding constitutional and related statutory matters and/or requests from stakeholders.
Second.
There's a motion and a second. Is there any objection? No. Okay, such will be the order. We have it done. And Mr. Leonard, I want you to understand, I understand the assessors some of them are slimly staffed, they're all working, and you're trying to represent a large group, and I do appreciate it. So do not take any of this as a slight, because I think the communication is just difficult when there's so many actors and you have to balance so many. And I commend you for your Herculean task.
Well, I thank you. It is going to be a challenge, but I'm enjoying it, and I'm pleased to know that it's in the record now that Mr. Aprea and I are friends.
Yeah, you are. You're friends, but you failed to communicate. So
Oh, what a start.
okay, there we go. No, you'll enjoy each other's company. You're both great guys. Thank you. Okay, members, what else do we have here? Miss Richmond.
Next, we have an administrative matter, organization of the board.
All right. Do we even have to take an action?
I think we should just put it on the record.
Chief Counsel.
Chair Harkey, members of the board. So what I believe I've sent to all the members a memo. I did some research on this. The board has established a policy. You can continue with that policy if you wish, or you can change it to do something different. Under the policy you established, at the conclusion of this meeting, the new chair would be from the 1st District member Runner. The vice chair would be member Ma. Basically, what was decided was essentially a numerical order rotation of the chair of the board, with the exception of, I believe at the time it was originally passed, Member Horton had a longer term as chair, so we passed on the 3rd District just for this rotation. So that's currently what's in place. If the board chooses to do nothing, that's how it would continue, but the board's perfectly free to change things however they wish.
Any discussion, members?
Yes, members. I'm perfectly okay with rotating past the 3rd District. We had a wonderful run of about 5 years, which I'm excited about all the progress that we were able to make. However, I do believe that the body should take these matters up on a vote. There should be the nomination process. They established this. The last time that this matter came up, the members requested that they actually go through the nomination process and make a vote. And so I am not supportive of just a continuation based on a policy that we established some time ago.
I agree. I think that for transparency purposes, there should be a nomination and a vote, both chair and vice chair.
Okay. Then, okay, it seems like we're in agreement. Nominations are open.
So are we starting with the chair?
Yeah, I guess we can start with the chair. Yeah, sure. Let's start with the chair. Nominations are open for chair. Do I hear any nominations? Let's start with vice chair. Nominations are open for vice chair.
I would support Member Ma as vice chair. I mean, if she wants it. Well,
I'm chair now, so I feel like I need to hear nominations or not. And
Are we on the vice chair? So are you nominating?
Vice chair member Ma.
Second.
Okay, there's a motion and a second. Is there any objection? No? Okay, we have Vice Chair Member Ma. We still have chair.
Really?
Okay, well, I don't know what you guys are going to do, but somebody's got to make a nomination. I'm the chair now, and I don't feel like it's my place to make a nomination. I I assume we were going to do a rotation here.
Last year, the outgoing chair nominated the chair.
That was last year. This is
Well,
this. If I have
I
a
mean,
nom-
the rules sort of established in the absence.
I don't mind.
In the absence of a
anybody.
nomination, the current chair remains chair. I mean, that's basically how they continued it. When I was chair, there was no vote. It just continued, so.
I would take whatever motion somebody wants to throw out here. I mean, I thought we were just going to rotate.
Yes, and that was my assumption too, since we made a big stink of it 2 years ago about rotation, this was the way it's going to be, and now we want to change the rules.
Well, we actually changed the rules last year, not this year. Last year, we changed the rules and said, okay, we want to have a nomination. It wasn't this year that we changed it.
Well,
And-
So
that
okay,
is why I
Member
asked-
Ma, am I hearing that you're...
And I didn't
you're
change it, by the way. Last year,
nominating,
it came from other members that they wanted to have the vote take place. And so it was last year that we eliminated the process of continuing this.
And that's why I actually asked for Chief Counsel, the memo that we got. I asked for that memo because I was unclear. Was the policy that we set in 2016,
Yeah.
did that stand, or because we did take a vote in 2017, did that mean that we basically were saying that we were going to vote every year thereafter? And
So I actually read through the transcript and reviewed the minutes and reviewed the entire, well, not, most of the meeting itself on video. What this body did was you established a policy. What you did last year was you did not change the policy, but I can't remember the exact words that were used, but to confirm the policy, what you decided to do was go ahead and vote for the people who, under the policy, would have been in those positions anyway. So Member Horton had a very eloquent discussion when he originally made the proposal about how he enjoyed being the chair and that he felt it should be rotated among all the districts, and that's what established the policy. Last year, the policy wasn't changed. I think your chief counsel at the time told you you could either vote or not vote, and the board, as I understood the comments, decided to vote to confirm what was in your policy. So the policy has remained unchanged since Member Horton established it.
members, thank you very much. Could we take a pause and go into closed session, talk about closed session matters, and come back to this? And I need 5 minutes.
Okay.
Okay,
Is that, yeah?
Yep.
I guess we can. I'll recess this item, and
We do have one more item.
what's that?
The public comment for matters not on the agenda, if you want to dispense with that, we can do that as well.
Is there any public comment for matters not on the agenda?
Yes, we have.
Yes.
We have one.
Well, let's take it up. We just went through, we
so-
don't want to dispense any of that.
Yes. So just by way of description, we were asked by a person to put an item on the agenda, which the chair had agreed to, for items not on the agenda. Now, this is basically public comment for matters that are in the purview of this board, but not necessarily agendized. In this particular case, because the gentleman who requested the opportunity to make public comment has disability issues, he has requested that his statement be read. So it is being read today by our taxpayer rights advocate, Ms. Lisa Thompson.
Thank you.
I'm Lisa Thompson, the taxpayer rights advocate for the Board of Equalization, and I will be reading this statement exactly as it appears. I wanted to note there are some typographical errors, which I will state as written, so that the error is not mine. The header of this document contains the following statement: BOE public comment, February 2018, urgent significant assessment problem discovered. The footer contains the following statement: duties of the state board, local board, and assessor are articulated in NOF v. CCSF and GOV Code 25303, 15606, Revenue and Tax Code, Section 531. And the two-page statement reads as follows. State Board of Equalization. Urgent, a significant assessment problem has been discovered affecting 10 counties, including San Francisco, that adopted Revenue and Tax Code 480.5 more than 20 years ago. Government Code 15606D requires the State Board to prescribe reporting forms. Revenue and Tax Code 480.5 requires private grants by local government agencies to provide citizens must be reported annually to the assessor. Private use permits and private license agreements that grant permission to private citizens, the right to use and occupy public land for private profits and private benefits are not being reported to the assessor as required. This problem is the State Board has neglected to prescribe a usage form, report form, for 10 counties that have adopted by ordinance Revenue and Tax Code Section 480.5. In 2000, the State Board published a special topic survey on taxable possessory interest, and on page 38, the Board recognized the need for prescribing a usage reporting form for 480.5. The problem is the State Board never developed a reporting form for 480.5, causing tens of thousands of escaped assessments in San Francisco each year. In 2015, Mooney reported the escape assessment to the Assessors Watchdog program that 12,714 private use permits were escaping taxation. This discovery revealed a much broader systematic problem that affects 10 counties that also adopted 480.5, whereby the lack of a prescribed usage form and reporting instructions has enabled massive escape assessments not reported to the assessors. The State Board, local board, and assessor duties have been articulated by the courts in Knopf v. San Francisco. The High Court discussed the adverse effects and irreparable damages caused by the statute of limitation, thereby illustrating the urgency, necessity to enroll all escaped assessments upon discovery to mitigate permanent losses of public revenue. The 12,714 private use permits escaping in San Francisco amounts to $8 million of public revenue annually. If these taxable possessory interests are not enrolled by July 1, 2018, they will escape another year, causing further irreparable damages. Over $1 billion in escaped public revenues is lost annually among the 10 counties that adopted 480.5 2 decades ago and will continue until the State Board provides a reporting form with meaningful reporting instructions. Signed, Sean Carl Mooney. That concludes the statement.
Thank you. Thank you very much.
Thank you.
Madam Chair, I'm ready to go back to the organization of the board.
Okay, thank you.
Madam Chair, with great pleasure, I'd like to nominate George Warner from the 1st District to the position of Chair.
Is there a second on that?
Second.
Is there any objection?
Objection.
One objection. Please call the roll.
Chairwoman Harkey,
Aye.
Mr. Horton,
No.
Ms. Ma,
Aye.
Ms. Towers,
Aye.
motion carries.
Let me just share, Madam Chair, if I will, is that, no question of Mr. Runner's ability to chair the board. My local Democratic clubs and organizations are moving an initiative relative to Democrats supporting Republicans for leadership positions, and so that's, I have to be supportive of their concerns in that regard.
Mr. Horton. Really?
Really, Mrs.
Really?
Member Ma, really?
Okay. I think it's done. Thank you. Thank you very much.
Our next item is closed session. The members will now go into closed session to discuss personnel matters.
Is there anything to report out from closed session?
The members met in closed session to discuss personnel matters, and there is no announcement.
Thank you very much. All right, we will adjourn this meeting of the State Board of Equalization. Thank you very much for your time and attention, and we'll see you next month.
Thank you.